Good morning, sir. This is Purvan from law school, sir. So we are just waiting for the other dignitaries to join in, sir. We'll start at 10:30, sir.
Hello.
Yes, sir. Yes, sir.
Can you hear me? Hello.
Yes, I can hear you now, sir.
Uh, uh, who is anchoring? Everybody is ready, huh? Anchor.
Yes, sir. Rashmi is anchoring, sir.
It's also ready, huh?
Yeah. Everybody is ready, sir.
Okay.
Yes, sir. Everything is ready, sir.
Sir. Sir.
We are just waiting for the dignitaries to join in, sir, and then we'll be able to start, sir. As per schedule, we'll start, sir.
Okay.
Yes, sir. Yes, sir. Thank you, sir.
Good morning, sir.
Good morning. Good morning.
Sir.
Law minister join ಆಗಬೇಕಲ್ಲ.
ಹ್ಞೂ ಸರ್ ಜಾಯ್ನ್ ಆಗ್ಬೇಕು ಸರ್. ಇವರು ಡೈರೆಕ್ಟರ್ ಸರ್ ಜಾಯ್ನ್ ಆಗಿದ್ರು.
ಹೌದು.
ಹಾಂ ಅಲ್ಲ ಹೆಡ್ಫೋನ್ ಹಾಕೊಂಡ್ಬಿಡ್ರಿ ಸುಮ್ಮನೆ ನಿಮ್ದು ಗುರುವೆ ಹೆಡ್ಫೋನ್ ಹೌದಿಲ್ಲ Good morning, sir. What is sir? Hello. One. Sir.
Good morning, Rajendra Itungere.
Good morning, sir. Good morning,
Good
sir.
morning, Professor
Good morning.
Revaya.
Good morning,
Ah.
sir. Good morning.
Ishwar Bhatta, good morning.
Namaskar, sir. Good morning. Good morning.
Yes, good morning, sir.
I'm there on the line, no problem.
Thank you. Thank you so much, sir. Thank you.
Okay,
Well in time, sir. Welcome, sir.
thank you. I'll be there, no problem.
Yes, sir. Yes, sir.
Yeah.
Good morning, sir.
Good morning, sir.
Good morning, Rajan.
Good morning, sir.
Sir. Good morning.
Justice sir already had joined earlier.
Yeah. Where is breakout room? Aditya. Aditya?
Sir, yes, sir. Good morning, sir.
Hey, you create breakout room and send all the to the breakout room.
Okay, sir.
Hello, good morning, sir. Good morning, everybody, sir.
Sir, good morning, sir. Dwarkanath
morning,
Babu,
sir.
sir. Good morning, sir. Sir, returning, sir. Good morning.
Good
JB
morning,
Patil, sir.
sir.
Good morning, sir.
Rangsamy, sir.
Good morning to all. Good morning, sir. Good morning.
Revay Odaya, sir. Good morning.
Good morning, sir. Good morning. Good morning, everybody.
Good morning, sir.
Good morning, sir. Aditya?
Sir, open ಮಾಡ್ತಿದ್ದೀನಿ, sir.
Now you could send all the guests to the breakout. You only send Aditya. Still we have 10 minutes.
Sir, I'll send.
ವರ್ಕ್ ಆಗಲ್ಲ.
Odaya, sir. Dwarkanath Babu, sir.
ಹಲೋ ಹೇಳಿ. ಹಲೋ ಹಲೋ
Hello, sir. Namaskar.
ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಸರ್. ಈಶ್ವರ್ ಭಟ್ ಅಷ್ಟು ನಮಸ್ತೆ. ಕೇಳುತ್ತಲ್ಲ?
Good morning, sir. Good morning.
Thank you. ಫೋಟೋ ಇದೆ ನೋಡಿ, ಇನ್ನೊಂದು ಫೋಟೋ ಬರ್ತಾ ಇದೆಯಲ್ಲ, ಇದರಲ್ಲಿ ನೋಡಿ ಬರ್ತಾ ಇದೆ.
Aditya.
Sir, yes, sir.
Sir, Justice Banurmat, sir, still in this general platform. Could you send him to breakout room?
Sir, we have assigned him to breakout room, but he's not there.
Okay, okay, okay. ಇಟ್ಟಣಿಗೆ ಸರ್ ಇದರಲ್ಲ ಇಲ್ಲಿ ಇಟ್ಟಣಿಗೆ ಸರ್.
ಸರ್ ಜಾಯ್ನ್ ಆಗ್ಲಾ ಸರ್ ನಾನು ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ ಅಥವಾ
ಸರ್ ಇಲ್ಲೇ ಇರೋಣ ಸರ್ ನಾವು
ಹೊರಗಡೆನೇ ಇರೋಣ ಅಲ್ವಾ? ಹಾ ಸರ್
ಹೊರಗಡೆ ಇರೋಣ ಅವರು ಗೆಸ್ಟ್ಗಳು.
ಓಕೆ.
ಮೇಡಮ್ ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಮೇಡಮ್. ಆದಿತ್ಯ ಮೇಡಮ್ ಕಳಿಸಿ.
Sir, we have assigned madam to room number 1, sir.
ಮೇಡಮ್ ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ ಇದೆ ಮೇಡಮ್, ಹೋಗ್ಬಿಟ್ಟು ಮೇಡಮ್.
Okay, I will join.
Sir, all the guests they are in breakout room, sir. Banurmat sir, you two could join, sir. ಹೋದ್ರು. Yes. ಇಟ್ಟಣಿಗೆ ಸರ್ ಎಲ್ಲರೂ ಅಲ್ಲಿದ್ದಾರೆ ಅನ್ಕೊಳ್ತೀನಲ್ಲ ಸರ್ ಗೆಸ್ಟ್ಗಳೆಲ್ಲ?
ಹಾ ಸರ್ ಇದ್ದಾರೆ ಸರ್.
ಗ್ರೇಟ್. ನಾವು ಸ್ಟಾರ್ಟ್ ಆದ್ಮೇಲೆ ಕರ್ತಾರಣ ಸರ್.
ಆದಿತ್ಯ ಅವರಿಗೆ ಇನ್ನೊಂದು ದ್ವಾರಕನಾಥ್ ಬಾಬು ಸರ್ ಇನ್ನೊಂದು ಹೋಸ್ಟ್ ಮಾಡ್ಬೇಕಂತ ಇನ್ನೊಂದು ಲಿಂಕ್, ಅದು ಡೈರೆಕ್ಟರ್ ಅಂತ ಇದೆ ನೋಡಿ, ಡೈರೆಕ್ಟರ್ ಕಿಲ್ಪಾರ್.
ಡೈರೆಕ್ಟರ್ ಕಿಲ್ಪಾರ್ ಆದಿತ್ಯ ನೋಡ್ರಿ, ಡೈರೆಕ್ಟರ್ ಕಿಲ್ಪಾರ್ ಎಲ್ಲಿದೆ ಅಂತ ಹೇಳಿ.
Sir, ಕೋಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
ಅಲ್ಲಪ್ಪ ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ ಅಲ್ಲಿ ಕಳಿಸಿದಿ. ಇಲ್ಲಿ ಒಬ್ರು ಜಸ್ಟಿಸ್ PS ನಾರಾಯಣ್ ಅಂತ ಹೇಳಿದಾರೆ ನೋಡಿ, ಅವ್ರನ್ನು ಕಳಿಸ್ತೀರಿ ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ಗೆ. ಸರ್ ರಶ್ಮಿ ಜಾಯ್ನ್ ಆಗಿದ್ದಾಳೆ ಸರ್.
Sir, Rasmi has joined, sir.
Good morning, sir.
Yeah,
I'm here.
Okay. ಸರ್ ಲಾ ಮಿನಿಸ್ಟರ್ದು ಕಾರಣ ಸಿಗ್ತಾ ಇದೆಯಾ ಸರ್ ಇಟ್ಟಣಿಗೆ ಸರ್?
ಮಿನಿಸ್ಟರ್ ಒಂದು ಸಿಗ್ತಾ ಇಲ್ಲ ನೋಡಿ ಸರ್, ಅಲ್ಲಿ ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ ಅಲ್ಲಿ ಇದಾರೆ ನೋಡಿ ಸರ್. ಬೇಕಾದ್ರೆ
ಒಂದ್ ನಿಮಿಷ ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ ಹೋಗ್ತೀನಿ.
ಹಾ ಸರ್.
Excuse me, sir. Yeah, all the dignitaries are sent to the breakout rooms, sir.
Including law minister?
All the dignitaries have been sent. Yes, sir.
No, whether law minister has joined?
Yes, sir. Yes, sir. Yes.
Oh, great. So then exactly at 10:30 let us start.
Okay, sir. Okay, sir.
So at 10:30 you have to bring all the guests over here.
Okay, sir. Okay, sir. Okay, sir.
ಆದಿತ್ಯ ನನಗೊಂದು ಆಪ್ಷನ್ ಕೊಡ್ರೆ ಹೋಗಿ ಬರ್ತೀನಿ ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ಗೆ, ನನಗೆ ಆಪ್ಷನ್ ಇಲ್ಲ.
Sir, we have given you the permission, sir.
Yeah, it is there. Okay, thank you. Sir, good morning, sir. Sir, registered sir join ಆದ್ರು.
ಹಾ ಸರ್, ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಸರ್. ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಸರ್.
ಆದಿತ್ಯ.
Good morning, sir. Yeah, sir, we have
Hello.
sent the request.
Sir, good morning.
We have sent the
Jubair
request.
sir. Sir, Jubair sir, ಅದು ಆಪ್ಷನ್ ಇದೆ ನೋಡಿ ಸರ್, ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ಗೆ. ಕೈಂಡ್ಲಿ ಜಾಯಿನ್ ದಟ್ ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ ಸರ್.
ಓಕೆ, ಯಾರು ಸರ್?
ಗೆಸ್ಟ್ ಗಳೆಲ್ಲ ಅಲ್ಲಿದ್ದಾರೆ ಸರ್.
ಓಕೆ ಓಕೆ.
Excuse me, sir. Sir, it's 10:30.
ರಂಗಸ್ವಾಮಿ ಸರ್.
ಆದಿತ್ಯ, ಅಭಿದಯ್.
Yes, sir. Yes, sir. Yes, sir.
ಗೆಸ್ಟ್ ಎಲ್ಲರೂ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ ಈಗ. ಯು ಬ್ರಿಂಗ್ ದಮ್ ಓವರ್ ಹಿಯರ್.
Okay, sir. Okay, sir. Okay, sir.
ಎಲ್ಲರೂ ಇದ್ದಾರೆ. ತರ್ತನ್ರಿ.
Aditya, breakout rooms ತೆಗಿ.
ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಲಾ ಮಿನಿಸ್ಟರ್ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ.
ಕರ್ಗಿ ಕೂತ್ಕೊಳ್ಳಿ ಅವರು ಅಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ.
Madam, shall we start, madam?
Yes, we can begin the program.
Rashmi.
Yes, sir. Start. So, very good morning, everyone. This is Rashmi P. Mandi, student, KSLU's Law School, and it gives me immense pleasure to welcome all the dignitaries, distinguished invitees, and participants to the national webinar on human rights, history and implementation and perspective, organized by the Karnataka Institute for Law and Parliamentary Reforms, Bengaluru, in association with Karnataka State Law University, Hubballi. As a tradition, let us commence by invoking the blessings of Lord Almighty by Lavanya, student, KSLU's Law School. Saraswati Purvega Duvyamati Saraswati Purvega Duvyamati Mridahari Haya Mokha Rodeyane Ninnaya Mridahari Haya Mokha Rodeyane Ninnaya Adiganige Raghove Amma Brahmana Rani Adiganige Raghove Amma Brahmana Rani Koduvega Duvyamati Saraswati Koduvega Duvyamati Patita Pavani Neenu Gatiyendu Nambide Patita Pavani Neenu Gatiyendu Nambide Sadata
श्री पुरंदर विठ्ठलन तोरे सतत श्री पुरंदर विठ्ठलन तोरे कोडो बेग दिव्यमती सरस्वती कोडो बेग दिव्यमती सरस्वती कोडो बेग दिव्यमती.
Thank you so much, Lavanya. May I request Professor Dr. Ratna R. Baramgowda, Dean and Director, KSLU, to kindly welcome the dignitaries and participants. Please, ma'am.
Thank you, Rashmi. A very good morning to you all. Distinguished dignitaries, esteemed syndicate and academic council members, invitees, esteemed principals from our affiliated law colleges, dear faculty members, and dear students. It's a great privilege for me to extend a warm welcome to all on this very momentous occasion of National Webinar on Human Rights, History and Implementation Perspective. Today's national webinar has been jointly organized by Karnataka Institute for Law and Parliamentary Reform, Bengaluru, and Karnataka State Law University, Hubballi. The belief that everyone, by virtue of humanity, is entitled to certain human rights is fairly new. Its roots, however, lie in earlier tradition and documents of many cultures like Hindu Vedas, the Babylonian Code of Hammurabi, the Bible, the Quran, and some other oldest written sources. It took the catalyst of World War II to propel human rights onto global stage and into the global conscience. A new world order came into being in the aftermath of World War II in 1945, putting respect for human rights alongside peace, security, and development as the primary objectives of United Nations. The Universal Declaration of Human Rights, proclaimed in 1948, provided a framework for a series of international human rights conventions. Presently, almost all the national legislations are influenced by these conventions. Today, implementation of human rights takes many forms, ranging from monitoring by human rights treaty bodies and adjudication by international courts and tribunals, to capacity building by civil society organizations and human rights education at the grassroots level. To address on this topic of immense significance and importance, today's national webinar has been organized. On this occasion, we are highly honored to have esteemed Shri J.P. Madhuswami, Honorable Minister for Law, Parliamentary Affairs and Legislation, and Minor Irrigation, and Pro-Chancellor of Karnataka State Law University, to inaugurate this national webinar. We are extremely delighted by your presence, sir, and on behalf of KILPAR and KSLU, I extend a warm and cordial welcome to you, sir. Welcome, sir.
Thank you, madam.
We have Honorable Justice S.R. Bannurmat, Chairman, Karnataka State Law Commission, and former Chief Justice, High Court of Kerala, as the resource person for the first session. Sir will be addressing on the topic, History of Human Rights and Human Rights Institutions. Sir, we are highly grateful to you for accepting our invitation. On behalf of KILPAR and KSLU, I extend a very hearty welcome to you, sir.
Thank you. Thank you.
We are immensely happy to have Honorable Vice Chancellor, Professor P. Ishwar Bhatt, as resource person for the second session. Sir will be addressing on the topic implementation of human rights and human rights courts. On behalf of all of us present here, I extend a very warm welcome to our Honorable Vice Chancellor. Welcome, sir.
Thank you, madam. Thank you.
Esteemed Shri K. Dwarkanath Babu, Director, Karnataka Institute for Law and Parliamentary Reform, Bengaluru, is presiding over the function. Sir was formerly syndicate member of Karnataka State Law University and has always extended his guidance, and he was highly supportive of all the endeavors of our university. Sir, it's a moment of great joy for me to welcome you on this occasion. Thank you, sir. I extend a very warm welcome to esteemed Shri Venkatesh Nayak, Principal Secretary, Law Department, and our esteemed Syndicate and Academic Council members. A cordial welcome to our Registrar, Mr. Mohammad Zubair. I also extend a hearty welcome to Professor G.B. Patil, Registrar Evaluation, Professor C.S. Patil, former Dean. Welcome, sirs. A warm and sincere welcome to all the invitees, esteemed principals from our affiliated colleges, dear faculty members and dear students. Last but not the least, I extend a hearty welcome to our program coordinators, Dr. Revaya Vadiar, Research Head Kilpar, Dr. Rangaswamy, Dr. Rajendra Kumar Hittangi, faculty members KSLU, and the team of our dedicated students who have put in a lot of efforts in organizing this program. A very warm welcome to all of them. Once again, I welcome one and all. With this, I conclude.
Thank you so much, ma'am. I would also extend a warm and a cordial welcome to you to the webinar. Welcome, ma'am. May I request Professor Dr. G.P. Patil, Registrar Evaluation, Karnataka State Law University, to kindly introduce Shri J.C. Madhuswamy, Honorable Minister of Law, Parliamentary Affairs and Legislation, and Minor Irrigation, Government of Karnataka, as well as the Pro-Chancellor of KSLU. Please, sir.
Good morning to all. Esteemed dignitaries, ladies and gentlemen, I deem it a privilege to introduce Shri J.C. Madhuswamy, Honorable Minister for Law and Parliamentary Affairs and Legislation, and Minister for Minor Irrigation, to this August gathering. Shri J.C. Madhuswamy was born on 4th February 1953 in Jayacharajpur, Tumkur district. He obtained degree in law from Vidyodaya Law College, Tumkur. He holds master's degree in arts. After a brief period of legal practice, he involved in social activities and political leadership. In 1982, he became chairman of Karnataka Milk Federation. He represents Jayacharajpura constituency of Tumkur district. From 1989 to 1994, he served as the member of Legislative Assembly. From 1996 to 1999, and from 2004 to 2007, he was again elected and served as the member of Legislative Assembly. In the year 2018, he got elected for the 15th Legislative Assembly and assumed as the member of Legislative Assembly. From 28 2019 to 21st January 2021, he served as the Minister for Minor Irrigation and Minister for Law and Parliamentary Affairs and Legislation. He was also the Pro-Chancellor of the Karnataka University during the said period. He has immensely helped and supported the university in all its endeavors. I feel proud to place on record that it is because of his efforts, the government of Karnataka established Vignaneshwara Adhyayana Pita at the university. The government was pleased to sanction 1 crore rupees for the functioning of the said Pita. The university is grateful to him forever for his support and making the university a center of research and learning. He has emerged as a persuasive public speaker and skilled in parliamentary debate. Hailing from agricultural family and having grassroots experience in his views reflect the concern for farmers, the poor, and the consumers. His mastery in constitution and parliamentary practice and laws often come to the surface in his debates. On 7/8/2021, he took charge as the Minister for Minor Irrigation and Minister for Law and Parliamentary Affairs and Legislation. We are happy to have him as the Pro-Chancellor of the Karnataka State Law University, Hubballi. ಒಂದು ಮಾತನ್ನ ಕನ್ನಡದಲ್ಲಿ ಶ್ರೀಯುತರ ಬಗ್ಗೆ ಹೇಳೋದಾದರೆ, ಕಾಯಕವೇ ಕೈಲಾಸ ಎಂದು ನಂಬಿರುವ ಶ್ರೀಯುತರು ಬಿಡುವಿಲ್ಲದ ಕಾರ್ಯಗಳಲ್ಲಿ ತಮ್ಮನ್ನು ತೊಡಗಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಸತ್ವಯುತ ಆಹಾರ ಸೇವನೆ, ಕರ್ತವ್ಯದಲ್ಲಿ ಮನಗೊಟ್ಟು ಕಾರ್ಯನಿರ್ವಹಣೆ, ಜೀವನವನ್ನು ನಿಸರ್ಗವನ್ನು ಪ್ರೀತಿಯಿಂದ ಕಾಣುವುದು, ಸಾಮಾಜಿಕ ಕಾರ್ಯಗಳಲ್ಲಿ ಆಸಕ್ತಿ, ನಿರಂತರ ಅಭ್ಯಾಸದ ಮನೋವೃತ್ತಿ, ಬದುಕಿನ ಬಗ್ಗೆ ಆಸ್ಥೆ, ಪರರ ಬಗ್ಗೆ ಪ್ರೀತಿ, ತಾವು ನಂಬಿದ ತತ್ವ ಸಿದ್ಧಾಂತಗಳ ಪರಿಪಾಲನೆಗಾಗಿ ಎಂದೂ ಎಲ್ಲೂ ರಾಜಿ ಮಾಡಿಕೊಳ್ಳದ, ಮಾತಿಗೆ ಬದ್ಧರಾಗಿ ಹೃದಯ ವೈಶಾಲ್ಯವನ್ನು ಬೆಳೆಸಿಕೊಂಡು ಬಾಳುತ್ತಿರುವ ಬುದ್ಧಿಜೀವಿಗಳು. ಮಾನವೀಯ ಸದ್ಗುಣಗಳನ್ನೆಲ್ಲ ಪರಿಪೂರ್ಣವಾಗಿ ಮೈಗೂಡಿಸಿಕೊಂಡು ಬದುಕನ್ನೇ ಆರಾಧಿಸುತ್ತಿರುವ ಭಾವಜೀವಿ. ಶ್ರೀಯುತರು ನಮ್ಮ ಕಾರ್ಯಕ್ರಮವನ್ನು ಉದ್ಘಾಟಿಸಲು ತುಂಬು ಹೃದಯದಿಂದ ಒಪ್ಪಿಕೊಂಡಿರುವುದು ನಮ್ಮೆಲ್ಲರಿಗೂ ಅತೀವ ಸಂತೋಷವನ್ನುಂಟು ಮಾಡಿದೆ ಎಂದು ತಿಳಿಸುತ್ತಾ, ಶ್ರೀಯುತರನ್ನ ಮತ್ತೊಮ್ಮೆ ಎಲ್ಲ ಸಂಘಟಕರ ಪರವಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಬರಮಾಡಿಕೊಳ್ಳುತ್ತೇನೆ. ನಮಸ್ಕಾರ.
Thank you so much, sir. It is an honor and privilege to have Shri J.C. Madhuswamy, Honorable Minister of Law, Parliamentary Affairs and Legislation and Minor Irrigation, and the Pro-Chancellor of KSLU. May I request sir to kindly inaugurate the webinar and deliver the inaugural address. Please, sir.
ನ್ಯಾಯಮೂರ್ತಿ ಸನ್ಮಾನ್ಯ ಶ್ರೀ ಬನ್ನೂರ್ಮಠ ಅವರೇ, ಮಾನ್ಯ ಈಶ್ವರ ಭಟ್ ಅವರೇ, ದ್ವಾರಕನಾಥ್ ಬಾಬು ಅವರೇ, ವಿಶ್ವವಿದ್ಯಾನಿಲಯದ ಎಲ್ಲ ವ್ಯವಸ್ಥಾಪಕರೇ, ಸ್ನೇಹಿತರೆ, ಏನು ಪಾಟೀಲ್ ಸಾಹೇಬ್ರು ಇವತ್ತು ಬಹಳ ಮಾತಾಡಿದ್ದಾರೆ ನನ್ನ ಬಗ್ಗೆ, ಹಾಗಾಗಿ ನಾನು ಸ್ವಲ್ಪ ಎಮೋಷನಲ್ ಆದ್ದೆ ಅಂತ ಅನ್ಸುತ್ತೆ. ಈಗ ನಾವು ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಬಗ್ಗೆ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಇವತ್ತು ಆರಂಭ ಮಾಡಿದ್ದೇವೆ. ನಾನು ಬಹಳ ಹೊತ್ತು ತಗೊಳೋದಿಲ್ಲ. ಬಿಕಾಸ್ ಲೈಫ್ ಈಸ್ ಆಕ್ಸಿಡೆಂಟಲ್ ಅಂತ ತಿಳ್ಕೊಂಡ್ರು ನಾನು, ಬರ್ತ್ ಈಸ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಂತ ತಿಳ್ಕೊಂಡ್ರು ನಾನು. ಬರ್ತ್ ಈಸ್ ಆಕ್ಸಿಡೆಂಟಲ್ ಅಂತ ಬಂದಾಗ ಜೀವನ ನಿರ್ವಹಣೆ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವೇನೇನ್ ರೂಪುರೇಷೆಗಳನ್ನ ಮಾಡ್ಕೋಬೇಕು, ಹೇಗಿರ್ಬೇಕು, ಸಹಬಾಳ್ವೆ ಅಂದ್ರೆ ಏನು, ಇದೆಲ್ಲದನ್ನು ಕೋಡಿಫೈ ಮಾಡೋ ಅಗತ್ಯ ಇತ್ತು. ಶ್ರುತಿ ಮತ್ತು ಸ್ಮೃತಿಗಳಿಂದ ನಾವು ಸಂವಿಧಾನನ ರಚನೆ ಮಾಡ್ಲಿಕ್ಕೆ ರೂಪ ಮಾಡ್ಕೊಂಡು ಅಂತ ಹೇಳಿ ಆರಂಭದಲ್ಲಿ ಮೇಡಮ್ ಅವ್ರು ಹೇಳಿದ್ರು. ಹಾಗೇನೆ ಮನುಷ್ಯನ ಹುಟ್ಟು ಆಕಸ್ಮಿಕ ಆದ್ರಿಂದ ಅದಕ್ಕೆ ಅಷ್ಟೊಂದು ಶ್ರೇಷ್ಠತೆನ, ಅದಕ್ಕೆ ಅಷ್ಟೊಂದು ಮಹತ್ವನ ಕೊಡೋದು ಅಗತ್ಯ ಇತ್ತಾ ಇರ್ಲಿಲ್ವಾ ಅಂತ ಚರ್ಚೆ ಮಾಡಿದಾಗ ಬಹುಶಃ ನಮ್ಮ ಭೂ ಜಗತ್ತಲ್ಲಿ ಹುಟ್ಟಿನ ಆಧಾರದ ಮೇಲೆ, ರೇಷಿಯಲ್ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಮೇಲೆ, ಧರ್ಮದ ಆಧಾರದ ಮೇಲೆ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಒಂದಕ್ಕೊಂದಕ್ಕೆ ತಾರತಮ್ಯಗಳನ್ನ ನಾವು ಸೃಷ್ಟಿ ಮಾಡಿದ್ವಿ. ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಕೆಲವರೇ ಈ ಎಲ್ಲ ಸವಲತ್ತುಗಳನ್ನ ಒಡೆಯರಾಗೋದು, ಎಲ್ಲದನ್ನ ಅನುಭವಿಸೋದು, ಎಲ್ಲದಕ್ಕೂ ಅವರೇ ಧನಿಗಳಾಗುವಂತ ಕಾಲ ಇತ್ತು. ಇದನ್ನ ಮನಗಂಡು ಒಂದ್ ಕಡೆ ಗುಲಾಮ್ಗಿರಿ, ಇನ್ನೊಂದ್ ಕಡೆ ಯಜಮಾನ್ಗಿರಿ, ಒಂದ್ ಕಡೆ ಆಳೋರು, ಇನ್ನೊಂದ್ ಕಡೆ ಆಳಿಸ್ಕೊಳೋರು, ಈ ಭಾವನೆಗಳೇನು ಇತ್ತು, ಈ ವ್ಯವಸ್ಥೆ ಏನಿತ್ತು, ಇದನ್ನ ಸ್ವಲ್ಪ ಮಟ್ಟಿಗೆ ಸುಧಾರಣೆ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿ ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ ಇನ್ 1948 ವಿಶ್ವಸಂಸ್ಥೆ ಮುಂದೆ ಆಯ್ತು. ಅದರ ಮೂಲ ಉದ್ದೇಶ ಮನುಷ್ಯರೆಲ್ಲ ಒಂದೇ, ಎಲ್ಲರಿಗೂ ಬದುಕೋ ಹಕ್ಕಿದೆ, ಎಲ್ಲರಿಗೂ ಬದುಕಲಿಕ್ಕೆ ಸಮಾನವಾದ ಅವಕಾಶಗಳು ಸೃಷ್ಟಿಯಾಗಬೇಕು, ಆ ಬದುಕಿಗೆ ಪೂರಕವಾಗಿ ಏನೇನು ಆಯೋಜನೆಗಳಾಗಬೇಕು ಅವನ್ನೆಲ್ಲ ನಾವು ಅವರ ಕೈಗೆ ಎಟ್ಕುವಂತ ಸ್ಥಿತಿನಲ್ಲಿ ಇಡಬೇಕು. ಯಾರಿಗೂ ಯಾವುದೇ ಬೇರೆ ಆಧಾರದ ಮೇಲೆ ಕೆಲವಕ್ಕೆ ಫ್ರೀ ಎಕ್ಸೆಸ್ ಇರಬಾರ್ದು, ಕೆಲವಕ್ಕೆ ರಿಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ಇರಬಾರ್ದು ಅನ್ನೋದಾಗಿತ್ತು ಅಂತ ತಿಳ್ಕೊಂಡ್ರು ನಾವು. ಹಾಗಾಗಿ ಈ ರೇಷಿಯಲ್ ಭಾವನೆ ಏನಿತ್ತು ಇದನ್ನ ತೆಗಿಲೇಬೇಕು, ಇದನ್ನೇನಾದ್ರೂ ಹೋಗ್ಲಾಡಿಸ್ತೇ ಹೋದೆ. ಯಾಕೆಂದ್ರೆ ಈ ಭಾವನೆಗೆ ಪೂಜ್ಯ ಮಹಾತ್ಮ ಗಾಂಧಿ ಅವರಂತರೊಳಗಾದ್ರು, ಬೇರೆ ಬೇರೆ ದೊಡ್ಡ ನಾಯಕರುಗಳು ಕೂಡ ಈ ಜನಾಂಗೀಯ ನಿಂದನೆ ಮತ್ತು ಆಪಾದನೆಗಳು ಒಳಗಾಗಿತ್ತು. ಅಂಥದನ್ನೆಲ್ಲ ಗುರ್ತಿಸಿ ವಿಶ್ವಸಂಸ್ಥೆ ಮನುಷ್ಯರೆಲ್ಲ ಒಂದೇ ಅಂತ ಹೇಳಿ ತೀರ್ಮಾನ ತಗೊಂಡು 1948ರಲ್ಲಿ ಮಾನವ ಹಕ್ಕುಗಳ ಬಗ್ಗೆ ಚರ್ಚೆನ ಆರಂಭ ಮಾಡ್ತು. ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ ಆಯ್ತು. ನಾವು ಸುಮಾರು ರಾಷ್ಟ್ರಗಳು ಅದಕ್ಕೆ ಪಾರ್ಟಿ ಆದ್ವಿ. ನಮ್ಗೆ ಗೊತ್ತು, ಇವತ್ತು ಅವ್ರಾಗ್ಲೇ ಮಾತಾಡ್ತಾ ಹೇಳ್ದಾಗೆ ಆಲ್ಮೋಸ್ಟ್ ಆಲ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ನಾವೇನ್ ಸಂವಿಧಾನದಲ್ಲಿ ಇವತ್ತು ಗ್ಯಾರಂಟಿ ಮಾಡಿದ್ದೀವಿ, ಇದಕ್ಕೆಲ್ಲ ಮೂಲ ಆಧಾರ ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ ಅಂತ ಹೇಳಿ ನಾವು ತಿಳ್ಕೊಬೇಕು. ಒಬ್ಬ ಮನುಷ್ಯನಿಗೆ ನಾವೇನು ಹಕ್ಕನ್ನ ಕೊಟ್ಟಿದ್ದೀವಿ, ಆ ಹಕ್ಕನ್ನ ಕೊಡ್ಲಿಕ್ಕೆ ನಮ್ಗೆ ಮೂಲ ಆಧಾರ ಸಿಕ್ಕಿದ್ದು ನಾವು ಡಿಕ್ಲರೇಷನ್ ಇಂದ. ಹಾಗಾಗಿ ಮನುಷ್ಯ ಅನ್ನೋನು ಒಂದು ರಾಷ್ಟ್ರದೊಳಗೆ ಪ್ರಜೆಯಾಗಿ ಹೇಗ್ ಬಾಳ್ಬೇಕು, ಅವನಿಗೆ ಹೇಗೆ ಬಾಳ್ಲಿಕ್ಕೆ ಅನುಕೂಲಗಳು ಸೃಷ್ಟಿ ಆಗ್ಬೇಕು, ಅವನು ಹೇಗೆ ತಾರತಮ್ಯಗಳು ಒಳಗಾಗಬಾರ್ದು, ಇವೆಲ್ಲ ಚರ್ಚೆಗಳನ್ನ ಆರಂಭ ಮಾಡಿ ನಾವು ಎಲ್ಲಾರ್ಗು ಒಂದು ಶಾಂತಿ ಮತ್ತು ಸಮಾಧಾನದಿಂದ ಸ್ಪರ್ಧಾತ್ಮಕವಾದ ಜೀವನ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶಗಳನ್ನ ಕಲ್ಪಿಸ್ಕೊಡ್ಲಿಕ್ಕೆ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಒಳಗೆ ನಾವು ಅವಕಾಶನ ಮಾಡಿಕೊಟ್ವಿ. ಇದು ಜೊತೆಗೆ ಕೆಲವು ಲೀಗಲ್ ರೈಟ್ಸ್ ಕೂಡ ನಾವು ಇವತ್ತು ಸೃಷ್ಟಿ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀವಿ. ಅದಕ್ಕೂ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ನಮ್ಗೆ ಈ ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ಸ್ ಪ್ರೇರಣೆ ಆಗಿದ್ದು. ನಿಮ್ಗೆ ಗೊತ್ತು, ಕಾನ್ಸ್ಟಿಟ್ಯೂಂಟ್ ಅಸೆಂಬ್ಲಿ ಡಿಬೇಟ್ ಅಲ್ಲಿ ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ವಿಷಯಕ್ಕೆ ಬಂದಾಗ ಬಹಳಷ್ಟು ಚರ್ಚೆ ಆಗತ್ತೆ. ಒಂದ್ ಕಡೆ ಸ್ವಾತಂತ್ರ್ಯದ ಬಗ್ಗೆ ಮಾತಾಡ್ತೀವಿ, ಇನ್ನೊಂದ್ ಕಡೆ ಮಾನವ ಹಕ್ಕುಗಳ ಬಗ್ಗೆ ಮಾತಾಡ್ತೀವಿ, ಇನ್ನೊಂದ್ ಕಡೆ ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಮತ್ತು ಸೆಡಿಷನ್ ಇಂಥ ಲಾನು ನಾವು ತಂದು ಅದನ್ನು ಪನಿಷಬಲ್ ಅಫೆನ್ಸ್ ಅಂತ ಮಾಡಿ ಇಡ್ತಿದೀವಿ ಅನ್ನೋ ಕೂಡ ವ್ಯಾಪಕವಾಗಿ ಚರ್ಚೆ ಮಾಡಕ್ಕಾಗತ್ತೆ, ಮಾಡಾಗಿದೆ. ಯಾಕೆಂದ್ರೆ ಮನುಷ್ಯನಿಗೆ ಪ್ರಿವೆಂಟಿವ್ ಆಗಿ ಡಿಟೈನ್ ಮಾಡ್ತೀವಿ, ಮತ್ತೆ ನಾನ್ ಬೇಲಬಲ್ ಅಫೆನ್ಸಸ್ ಅಂತ ಮಾಡಿ ಕೆಲವ್ರನ್ನ ವಿಚಾರಣೆ ಇಲ್ದಲೇನೆ ತಗೊಂಡೋಗಿ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇಟ್ಕೊಳೋದು, ಬ್ಯಾರಕ್ಕಲ್ಲಿ ಇಡೋದು, ಇದೆಲ್ಲ ಏನಿತ್ತು ಇದು ಒಬ್ಬ ವ್ಯಕ್ತಿಯ ಸ್ವಂತ ಜೀವನದ ಮೇಲೆ ಬಿಡ್ತಾ ಇದ್ದಂತ ಹೊಡ್ತಾ ಆಗಿತ್ತು. ಹಾಗಾಗಿ ನಾವು ಸುಮಾರು ಆರ್ಟಿಕಲ್ಸ್ ಅನ್ನ ಡಿರೈವ್ ಮಾಡಿಬಿಟ್ಟು ಎಲ್ಲೆಲ್ಲಿ ಹೇಗೆ ನಾವು ಕೆಲಸ ಮಾಡಬೇಕು ಅನ್ನೋ ಒಂದು ನಿಬಂಧನೆಗಳನ್ನ ಇವತ್ತು ಆಡಳಿತಕ್ಕೆ ಮತ್ತು ರಾಜ್ಯಾಂಗಕ್ಕೆ ನಾವು ಒದಗಿಸ್ಕೊಡ್ಲಿಕ್ಕೆ ನಮ್ಗೆ ಇವತ್ತು ಈ ನಮ್ಮ ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ ಬಹಳ ರೀತಿನಲ್ಲಿ ಪೂರಕವಾಗಿ ಮತ್ತೆ ಪ್ರೇರಣೆಯಾಗಿ ನಿಂತಿದೆ ಅಂದ್ರೆ ತಪ್ಪಾಗ್ಲಿಕ್ಕಾಗದ. ಇವತ್ತು ನಮಗ್ ಗೊತ್ತು, ಯಾರನ್ನು ನಾವು ನ್ಯಾಯಾಲಯದ ಗಮನಕ್ಕೆ ಬರ್ದಲೇನೆ ಅರೆಸ್ಟ್ ಮಾಡಿಡೋಂಗಿಲ್ಲ. ಭಾರಿ ಅಗತ್ಯ ಇದ್ರು 24 ಗಂಟೆಗಳ ಕಾಲ ದೊಳಗೆ ನಾವು FIR ಅನ್ನ ಹಾಕ್ಲೇಬೇಕಾಗತ್ತೆ. ಮತ್ತೆ FIR ಅನ್ನ ನಾವು ಕ್ವಶನ್ ಮಾಡಂಗಿಲ್ಲ, ಯಾರು ಏನ್ ಬೇಕಾದ್ರೂ ಬಂದು FIR ಅಲ್ಲಿ ಕೊಡ್ಬೋದು. ನಾವು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಅಥವಾ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಮಾತ್ರ ಪೊಲೀಸ್ನವ್ರಿಗೆ ಅಥವಾ ಆಡಳಿತಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟದನ್ನ ಹೇಳ್ಬೋದು. ಮತ್ತೆ ಮನುಷ್ಯ ಎಲ್ಲಿ ಬೇಕಾದ್ರೂ ಓಡಾಡ್ಲಿಕ್ಕೆ ಫ್ರೀ ಇರ್ಬೇಕು, ಯಾವ ಭಾಷೆ ಮಾತಾಡ್ಲಿಕ್ಕೂ ಅವನಿಗೆ ಸ್ವಾತಂತ್ರ್ಯ ಇರ್ಬೇಕು, ಯಾವ ಭಾಷೆನಲ್ಲಿ ಅಥವಾ ಯಾವ ಮೀಡಿಯಂ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಲ್ಲಿ ಅವನು ಎಜುಕೇಟ್ ಆಗ್ಬೇಕು, ಆ ಮಕ್ಳಿಗೆ ಎಜುಕೇಟ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಸ್ವಾತಂತ್ರ್ಯ ಇರಬೇಕು. ಅವನಿಗೆ ಪ್ರಾಪರ್ಟಿ ಹಕ್ಕು, ರೈಟ್ ಟು ಪ್ರಾಪರ್ಟಿ, ಟು ಓನ್ ಪ್ರಾಪರ್ಟಿ ಅವನಿಗೆ ಹಕ್ಕು ಕೊಡ್ಬೇಕು. ಫ್ರೀ ಟ್ರೇಡ್, ಅವನಿಗೆ ಇಡೀ ರಾಷ್ಟ್ರದೊಳಗೆ ಆ ಬೌಂಡ್ರಿ ಒಳಗಡೆ ಅವನಿಗೆ ಟ್ರೇಡಿಂಗ್ ಈಗ ಹಕ್ಕು ಕೊಡ್ಬೇಕು. ಇವೆಲ್ಲವನ್ನ ನಾವೇನ್ ಚರ್ಚೆ ಮಾಡ್ತಿದ್ವಿ, ಅವನಿಗೆ ಸಂಘಟನೆ ಮಾಡ್ಲಿಕ್ಕೆ ಹಕ್ಕು ಕೊಡ್ಬೇಕು, ಪ್ರಾಪಗೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇಸ್ ರಿಲಿಜಿಯನ್ ಅಂಡ್ ಇಸ್ ಪರ್ಸನ್ ನಾವು ಹಕ್ಕು ಕೊಡ್ಬೇಕು. ಧರ್ಮ ನಿರಪೇಕ್ಷಿತ, ಯಾರು ಯಾವ ಧರ್ಮ ಬೇಕಾದ್ರೂ ಆಚರಿಸ್ಲಿಕ್ಕೆ ಪ್ರೊಫೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು ಅವನಿಗೆ ಅವಕಾಶ ಕೊಡ್ಬೇಕು. ಅದನ್ಗೆ ಮದುವೆ ಆಗ್ಲಿಕ್ಕೆ, ಆತ ಇಂಟರ್ಕ್ಯಾಸ್ಟ್ ಮ್ಯಾರೇಜ್ ಆಗ್ಲಿಕ್ಕೆ, ಮತ್ತೊಂದಾಗ್ಲಿಕ್ಕೆ ಯಾವುದಕ್ಕೂ ನಾವು ಆತ ಪ್ರೌಢ ಆದ್ಮೇಲೆ 18 ಅಥವಾ 21 ಆದ್ಮೇಲೆ ಆತನ ಚಿಂತನೆ ಆತ ಮಾಡ್ಲಿಕ್ಕೆ ಯೋಗ್ಯ ಆದ್ಮೇಲೆ ನಿರ್ಬಂಧ ಮಾಡ್ತಕ್ಕದ್ದಲ್ಲ ಅಂತ ನಾವು ಸ್ಪಷ್ಟಪಡಿಸಿದ್ದೇವೆ. ಇದ್ರಲ್ಲಿ ಗೊತ್ತು ಟ್ರೇಡ್ ಹೆಂಗಾಗ್ಬೇಕು, ಹೇಗೆ ಚುನಾವಣೆಗಳಲ್ಲಿ ನಿಲ್ಲಿಕ್ಕೆ ಹಕ್ಕು, ಚುನಾವಣೆಗಳಲ್ಲಿ ವೋಟ್ ಹಾಕ್ಲಿಕ್ಕೆ ಹಕ್ಕು, ಒಬ್ಬರಿಗೆ ಒಂದೇ ಮತದಾನದಕ್ಕೂ ಎಷ್ಟೇ ದೊಡ್ಡವರಿರ್ಲಿ, ರೈಟ್ ಆಫ್ ಇಸ್ ಪ್ರೊಫೆಸ್ ಟು ರಿಲಿಜನ್ ಅನ್ನ ಕೊಟ್ಟಿದೀವಿ. ಇವತ್ತು ನಾವು ಮಾತಾಡ್ತಾ ಇದ್ದೀವಿ, ನಾವು ಧರ್ಮೀಯ ಹಕ್ಕನ್ನ ಏನ್ ಕೊಟ್ಟಿದೀವಿ, ಒಂದು ಧರ್ಮ ಅಥವಾ ಪೂಜೆ ಮನೆಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ನಿನ್ನ ಇಂಡಿವಿಜುವಲ್ ರೈಟ್ ಅಂತ ಹೇಳಿ ನಾವು ಪದೇ ಹೇಳ್ತೀವಿ. ಹಾಗಾಗಿ ಇನ್ನೊಬ್ಬರಿಗೆ ತೊಂದರೆ ಮಾಡದೆ, ಇನ್ನೊಬ್ಬರಿಗೆ ಅವಮಾನ ಮಾಡದೆ, ಇನ್ನೊಬ್ಬರ ಬದುಕನ್ನ ಅಸಹನೀಯ ಆಗದೆ ರೀತಿನಲ್ಲಿ ಯಾರಾದ್ರೂ ಆತನಷ್ಟಕ್ಕೆ ಆತ ಚೆನ್ನಾಗ್ಬೇಕು, ಬೆಳಿಬೇಕು, ಮುಂದೆ ಬರಬೇಕು, ಆತ ಏನಾದ್ರು ಪ್ರತಿನಿಧಿಸುವಂತ ಹಕ್ಕು ತಗೋಬಹುದು ಅಥವಾ ಪ್ರತಿನಿಧಿಸ್ಲಿಕ್ಕೋಸ್ಕರ ಯಾರಿಗಾರು ಮತ ನೀಡ್ಕೊಡ್ಬೇಕು. ಈ ಎಲ್ಲ ವಸ್ತುಗಳನ್ನ ನಾವು ಡಿಫ್ರೆಂಟ್ ಆರ್ಟಿಕಲ್ಸ್ ಅಲ್ಲಿ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಇವತ್ತು ನಾವು ಮನುಷ್ಯನಿಗೊಬ್ಬನಿಗೆ ಬದುಕ್ಲಿಕ್ಕೆ, ಗೌರವಿತವಾದ ಬದುಕ್ಲಿಕ್ಕೆ, ಒಂದ್ ಸಮಾಜದಲ್ಲಿ ಏನೇನು ಸ್ಥಿತಿಯನ್ನ ನಿರ್ಮಾಣ ಮಾಡ್ಬೇಕು ಆ ಎಲ್ಲ ಸ್ಥಿತಿಗಳನ್ನ ನಾವು ಈ ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ ಅಲ್ಲಿ ನೋಡ್ಬೋದು ನಾವು. ಹಾಗಾಗಿ ದಿಸ್ ಇಸ್ ಬೈಬಲ್, ಇದು ನಮ್ಗೆ ಮೂಲ. ಇವತ್ತು ನಮ್ಮ ಎಲ್ಲ ಸಂವಿಧಾನಗಳಿಗೆ, ಸಂವಿಧಾನದಲ್ಲಿ ಅಡಕಾಗಿರುವಂತ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ಗೆ ಬಹಳ ಮೂಲವಾದಂತ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನ ಅವತ್ತು UN ಅವರು ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಾಗಾಗಿ ಇವತ್ತು ನೋಡ್ತಾ ಇದ್ವಿ, ಅಂಡ್ ರೈಟ್ ಟು ಎಜುಕೇಶನ್ ಅಪ್ ಟು ದಿ ಏಜ್ ಆಫ್ 14 years ಎಲಿಮೆಂಟರಿ ಎಜುಕೇಶನ್ ಅನ್ನ ನಾವು ಸರ್ಕಾರನೇ ಕೊಡ್ಬೇಕು, ಆಡಳಿತ ಕೊಡ್ಬೇಕು. ಇತ್ತೀಚೆಗೆ ಫುಡ್ ಸೆಕ್ಯೂರಿಟಿ ಆಕ್ಟ್ ಅನ್ನ ನಾವು ಪಾಸ್ ಮಾಡಿದ್ವಿ. ಯಾರೂ ಉಪವಾಸ ಮಲಗಬಾರ್ದು, ಪ್ರಪಂಚದಲ್ಲಿ ಯಾರು ಹಸುವಿನಿಂದ ಸಾಯಬಾರ್ದು. ಹಾಗಾಗಿ ಉಪವಾಸ ಮಲಗ್ತಾರೆ, ಸಾಯ್ತಾರೆ, ಆ ಸ್ಥಿತಿ ಇದೆ ಅನ್ನೋದನ್ನ ಕಂಡು ಯುಎನ್ಒ ಆ ಹಕ್ಕನ್ನ ನಮ್ಗೆ ಕೊಟ್ಟಿದೆ. ಇವತ್ತು ನಾವು ಫುಡ್ ಸೆಕ್ಯೂರಿಟಿ ಆಕ್ಟ್ ಪಾಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಇಂಡಿಯಾ ದೇಶ ಅಷ್ಟೊಂದು ಸಮೃದ್ಧಿಯಾಗಿರ್ಲಿಲ್ಲ. 1,23,000 ಕೋಟಿ ಫಂಡ್ ಅನ್ನ ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ಬೇಕಾಗಿತ್ತು. ಆದ್ರೂ ವಿಶ್ವಸಂಸ್ಥೆಯ ಒತ್ತಡಕ್ಕೆ ನಾವು ಮಾಡಿದ್ವು ಫುಡ್ ಸೆಕ್ಯೂರಿಟಿ ಆಕ್ಟ್ ಅನ್ನ ಇವತ್ತು ಇಂಡಿಯಾನಲ್ಲಿ ಜಾರಿ ಮಾಡಿದ್ವಿ. ಹಾಗಾಗಿ ಸೆಕ್ಯೂರಿಟಿ ಇವತ್ತು ಎಲ್ಲರಿಗೂ ಇದೆ. ಹಾಗಾಗಿ ಆ ಸೆಕ್ಯೂರಿಟಿನ ಎನೇಬಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು NREG-ನ ಇಂಟ್ರಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ. ಒಬ್ಬ ಮನುಷ್ಯನಿಗೆ ಕನಿಷ್ಠ 100 ದಿವಸ ಕೂಲಿ ಸಿಗಲೇಬೇಕು. ಅಕಸ್ಮಾತ್ ಅವನಿರೋ ಭಾಗದಲ್ಲಿ ಕೂಲಿ ಸಿಗದೆ ಹೋದ್ರೆ ಅವನಿಗೆ ಕೂಲಿ ಮಾಡೋ ಕೆಲಸನ ಆತನಿಗೆ ಆ ಕೂಲಿ ಕೊಡ್ಬೇಕಾಗಿರೋ ಸಂದಾಯದ ಹಣನ ಸರ್ಕಾರನೇ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ ಎಲ್ಲ ಕಡೆ NREG ಪ್ರೋಗ್ರಾಮ್ ಅನ್ನ ಕೇಂದ್ರ ಸರ್ಕಾರದ ವತಿಯಿಂದ ನಾವು ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಯಾತಕ್ಕೆ NREG ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಪುಕ್ಷಟೆ ಯಾರಿಗೂ ಊಟಕ್ಕೆ ಹಾಕಕ್ಕಾಗೋದಿಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ ಲೆಟ್ ಹಿಮ್ ವರ್ಕ್ ಅಂಡ್ ಅರ್ನ್ ಹಿಸ್ ಲೈವ್ಲಿಹುಡ್ ಅಂತ ಹೇಳಿ ಮಾಡಿಕೊಟ್ಟು ಇವತ್ತು ಯಥೇಚ್ಛವಾಗಿ ನಾವು ನೋಡ್ತಾ ಇದೀವಿ. ಇವತ್ತು ಹಸುವಿನ ಸಾವು ನಮ್ಗಲ್ಲೆಷ್ಟು ಕಾಣ್ತಾ ಇಲ್ಲ. ಮೊದ್ಲೇ ಒಂದು ಕಾಲದಲ್ಲಿ ಇತ್ತು ಊಟಕ್ಕೆ ಹೇಗೆ ನಾಳೆಗೆ ಹೇಗೆ ಅಂತ. ಇವತ್ತು ಕೆಲಸ ಮಾಡೋರ್ಗೆಲ್ಲೂ ಆ ಸ್ಥಿತಿ ಇವತ್ತು ಇಲ್ಲ. ಈ ಸ್ಥಿತಿ ನಿರ್ಮಾಣ ಮಾಡೋ ಮಧ್ಯೆ ನಮ್ಮ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಕಮಿಷನ್ಗಳು ಬಹಳ ಕೆಲಸ ಮಾಡಿದೆ. ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಕಮಿಷನ್ ಮುಂದೆ ಅನೇಕ ಚಾಲೆಂಜಸ್ ಇದೆ. ಇನ್ನೂ ನಾವು ಲಿಂಗ ಭೇದಗಳನ್ನ ಮರ್ತಿಲ್ಲ. ಇಲ್ಲೂ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಸ್ತ್ರೀಯರು ಅಂದ್ರೆ ಅಬಲೆಯರು ಅನ್ನೋ ಮಾತನ್ನು ಬಿಟ್ಟಿಲ್ಲ. ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಈಗ್ಲೂ ಫ್ಯೂಡಲ್ ವ್ಯವಸ್ಥೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಮಾಧ್ಯಮಗಳು ಅವರು ಇವರು ಚರ್ಚೆ ಮಾಡೋದ್ ಬಿಟ್ಟಿಲ್ಲ. ಈಗ್ಲೂ ರೆಕಗ್ನಿಷನ್ ಬೈ ಬರ್ತ್ ಇನ್ನೂ ನಡೀತಾ ಇದೆ ಅಂದ್ರೆ ಅದು ಮಾನವ ಹಕ್ಕುಗಳ ಉಲ್ಲಂಘನೆ ಅಂತ ಹೇಳಿ ನಾವು ಭಾವಿಸಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅಂದ್ಕೋತಾ ಈ ಎಲ್ಲ ಭಾವನೆಗಳು ಒಂದು ಸಮಾಜದಲ್ಲಿ ಹುಟ್ಟಿದವನಿಗೆ ಅಲ್ಲಿ ಬದುಕ್ತಾ ಇರೋವನಿಗೆ ಯಾರು ಮೇಲಲ್ಲ ಯಾರು ಕೀಳಲ್ಲ, ಎಲ್ಲ ಸಮಾನ ಭಾವನೆ ಸೃಷ್ಟಿಯನ್ನ ಮಾಡ್ಬೇಕು. ಮತ್ತೆ ಸಮಾನಾದ ಅವಕಾಶಗಳನ್ನ ಕಲ್ಪಿಸ್ಬೇಕು. ಅವನಿಗೆ ಎಲ್ಲದಕ್ಕೂ ಈಸಿ ಅಕ್ಸೆಸ್ ಇರಬೇಕು, ಅಪ್ರೋಚ್ ಇರಬೇಕು. ಅನೇಕ ಕಡೆ ನಾನು ಹಿಂದೆ ನಮ್ಮ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಕಮಿಷನ್ ಆಫೀಸ್ಗೆ ಹೋದಾಗ ಹೇಳಿದ್ದೇನೆ, ಪೊಲೀಸ್ ಅಟ್ರಾಸಿಟೀಸ್, ಪೊಲೀಸ್ನವ್ರು ಮಾಡ್ತಿರೋ ತಪ್ಪುಗಳಿಂದಾಗಿ ಅನೇಕ ಜನಗಳ ಈ ರೈಟ್ ಉಲ್ಲಂಘನೆ ಆಗಿದೆ, ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಉಲ್ಲಂಘನೆ ಆಗಿದೆ. ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ಗೆ ಅವರು ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಅಡಚಣೆ ಮಾಡ್ತಾ ಇದಾರೆ ಅನ್ನೋ ಭಾವನೆ ಇದೆ. ಹಾಗಾಗಿ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಾದ್ರೂ ಅವ್ರ ಮುಂದೆ ಫೈಲ್ ಮಾಡ್ಬೇಕು, ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೇಕಾಗಿರೋದು ಅವರೇ ಮಾಡ್ಬೇಕು. ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಆದ್ರೆ ಸರ್ಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಎನ್ಕ್ವೈರಿ ಮಾಡು ಅಂದ್ರೆ ಆತ ಕೇಸ್ ಕ್ಲೋಸ್ ಮಾಡ್ಸಕ್ ಟ್ರೈ ಮಾಡ್ತಾನೆ ಬಿಟ್ರೆ ಆತ ಯಾರೋ ಅವ್ನ ಕೆಳಗಡೆ ಅಧಿಕಾರಿನ ತಪ್ಪಿತಸ್ಥ ಅಂತ ಮಾಡ್ಲಿಕ್ಕೆ ಮಾಡೋದಿಲ್ಲ. ಹಾಗಾಗಿ ಈ ಸ್ಥಿತಿನ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್ ಬೇರೆ ಕಡೆ ಮಾಡಂಗ್ ಮಾಡಿ, ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್ ಬೇರೆ ಕಡೆ ಆದ್ಮೇಲೆ ಈ ಎನ್ಕ್ವೈರಿನೂ ಕೂಡ ಬೇರೆ ಬೇರೆ ಸೋರ್ಸಸ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಮಾಡ್ಲಿಕ್ಕೆ ಅಗತ್ಯ ಇದೆಯಾ ಅಂತ. ಒಂದು ರೆವಿನ್ಯೂ ಆಫೀಸರ್ ಮೇಲೆ ನಮ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಬಂದ್ರೆ ಲೆಟ್ ಇಟ್ ಬಿ ಎನ್ಕ್ವೈರ್ಡ್ ವಿತ್ ಸಮ್ ಅದರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಅದೇ ಅಧಿಕಾರಿನ ಅದ್ರ ಮೇಲ್ಗಡೆ ಅಧಿಕಾರಿನ ಕೊಡೋದು, ನೀನ್ ತನಿಖೆ ಮಾಡಿ ವರದಿ ಕೊಡು ಅನ್ನೋದು ಯಾವ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಅಲ್ಲಿ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿರೋ ಅದಕ್ಕೆ ಏನ್ ಪರಿಹಾರ ಸಿಕ್ಕಲ್ಲ ಅನ್ನೋ ಸ್ಥಿತಿ ಏನಿದೆ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಅಲ್ಲಿ ಅಷ್ಟೊಂದು ಚೆನ್ನಾಗಿ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಅಂದ್ಕೊಳ್ಲಿಕ್ಕೆ ಎಸ್ ಲಾ ಮಿನಿಸ್ಟರ್ ನನ್ನ ಕಡೆಯಿಂದ ಆಗಿಲ್ಲ ಅಂತ ನಾನು ಅವ್ರ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಹೇಳಿ ಬಂದಿದ್ದೆ. ಹಾಗಾಗಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದವನಿಗೆ ಎಲ್ಲಾದ್ರೂ ಒಂದ್ ಕಡೆ ನನ್ನ ಬಗ್ಗೆ ಗಮನ ಹರಿಸ್ತಾರೆ, ನನ್ನ ಕಂಪ್ಲೇಂಟ್ ಕೂಡ ವ್ಯಾಲಿಡ್ ಆಗಿದೆ, ನನ್ನ ಕಂಪ್ಲೇಂಟ್ಗೆ ಮಹತ್ವ ಇದೆ, ಇಂಥ ಕಂಪ್ಲೇಂಟ್ ಒಂದೋ ಎರಡೋ ಆದ್ರೆ ಯಾರು ಈ ದುರಾಡಳಿತ ಮಾಡ್ತಾರೆ ಅವರನ್ನ ಒಂದ್ ಹದಕ್ ತರಬಹುದು ಅನ್ನೋ ಭಾವನೆ ಬರೋ ರೀತಿನಲ್ಲಿ ನಾವು ನಡ್ಕೋಬೇಕಾಗಿರೋದು ಇವತ್ತು ತೀರಾ ಅನಿವಾರ್ಯ ಆಗಿದೆ. ಶಿಕ್ಷಣ ಕೊಟ್ಟಿದ್ದೀವಿ. ಶಿಕ್ಷಣ ಕೊಡೋ ಉದ್ದೇಶ ಏನು? ಮನುಷ್ಯ ಸ್ವಾಭಿಮಾನದಲ್ಲಿ ಬಾಳ್ಲಿ ಅಂತ. ಆ ಮನುಷ್ಯನ ಸ್ವಾಭಿಮಾನಕ್ಕೆ ತೊಂದರೆ ಆದಾಗ, ಸ್ವಾಭಿಮಾನಕ್ಕೆ ಧಕ್ಕೆ ಬಂದಾಗ ಆತನಿಗೆ ಇನ್ನೇನು ಬೇಕಂತ ಅನ್ಸೋದೇ ಇಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಮನುಷ್ಯರಿಗೆ ಪ್ರಾಣಿಗಳಿಗಿರೋದು ಒಂದೇ ವ್ಯತ್ಯಾಸ, ಸ್ವಾಭಿಮಾನ ಮತ್ತು ಯೋಚನೆ ಮಾಡೋ ಸ್ಥಿತಿ. ಈ ಎರಡರ ಮಧ್ಯೆ ಏನಾದ್ರು ನಾವು ಪ್ರಾಣಿಗಳಂಗೆ ಬದುಕ್ತಾ ಇದೀವಿ ಅನ್ನೋ ಸ್ಥಿತಿನೇ ಮುಂದುವರ್ಸ್ಕೊಂಡು ಹೋದ್ರೆ ಹಕ್ಕುಗಳಿದೆ, ಮಾನವ ಹಕ್ಕುಗಳನ್ನ ನಾವು ಘೋಷಣೆ ಮಾಡಿದೀವಿ, ಅದ್ರ ಉಲ್ಲಂಘನೆ ಆದ್ರೆ ಕ್ರಮ ತಗೋತೀವಿ ಅನ್ನೋ ಪರಿಸ್ಥಿತಿ ಯಾರು ನಂಬೋದಿಲ್ಲ. ಹಾಗಾಗಿ ನಾವು ಇವತ್ತು ಎನ್ಶೂರ್ ಮಾಡ್ಬೇಕಾಗಿದೆ. ನಾವಿವತ್ತು ಎಲ್ಲಿ ಇವತ್ತು ಕಂಪ್ಲೇಂಟ್ ಬರುತ್ತೆ ಅದರ ತನಿಖೆನ, ಅದರ ವಿಚಾರಣೆನ ಸ್ವಲ್ಪ ಬೇರೆ ರೀತಿಯಲ್ಲಿ ಮಾಡಿ ಯಾರು ಇದನ್ನ ಮುಚ್ಚಾಕ್ಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತಿದ್ದಾರೆ ಅವ್ರಗಳ ಮೇಲೆ ಸ್ವಲ್ಪ ತೀವ್ರತರವಾದ ನಿಗಾ ಇಡೋ ಸ್ಥಿತಿನ ತರಬೇಕಾಗುತ್ತೆ. ಎರಡನೇದು, ಅನೇಕ ಪ್ರಕರಣಗಳಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋಕೆ ಬರಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋಕೆ ಆಗೋಲ್ಲ. ಅಲ್ಲಿರೋ ಅಥಾರಿಟಿ ಇರುವಂತ ಮನುಷ್ಯರು ಅಷ್ಟೊಂದು ದುರಹಂಕಾರದಲ್ಲಿ ವರ್ತಿಸ್ತಾರೆ, ಅಷ್ಟೊಂದು ಅಧಿಕಾರನ ಬಳಸ್ಕೋತಾರೆ. ಅವ್ರು ನಾವ್ ಏನ್ ಮಾಡಿದ್ರು ನಡೆಯುತ್ತೆ ಅನ್ನೋ ಸ್ಥಿತಿನಲ್ಲಿ ಇರೋ ಕಡೆ ಪಾಪ ಅಮಾಯಕರು ಸುಮ್ನೆ ಅವರ ಹಿಂಸೆಗೆ ಅಥವಾ ಕ್ರೌರ್ಯಕ್ಕೆ ಒಳಗಾದವರು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಕೂಡ ಎದುರಿಸೋ ಸ್ಥಿತಿ ಇರುತ್ತೆ ಇವತ್ತು. ಅದನ್ನ ನಾವು ಎಲ್ಲಾದ್ರೂ ಹೇಗಾದ್ರೂ ಮಾಡಿ ಸೋಮೋಟೋ ಕೇಸ್ ತಗೊಳೋದು ಅಥವಾ ಬೇರೆ ಮೂಲದಿಂದ ಏನಾದ್ರು ನಮ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಬಂದ್ರೆ ಎಂಟರ್ಟೈನ್ ಮಾಡೋದು, ಅಂತ ಅಧಿಕಾರಿಗಳ ಮೇಲೆ ನಾವೇನಾದ್ರು ಕ್ರಮ ಜರುಗಿಸ್ಲಿಕ್ಕೆ ಶಿಫಾರಸ್ ಮಾಡೋದು, ಈ ಕೆಲಸ ಕೂಡ ಇವತ್ತು ನಾವು ಮಾಡ್ಬೇಕಾಗಿದೆ. ಯಾಕೆಂದ್ರೆ ಕ್ರೌರ್ಯ ನಿಂತಿದೆ ಅಂತೇಳಿ ನಾವು ಭಾವಿಸಕ್ಕಾಗಲ್ಲ. ರೇಷಿಯಲ್ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಅಥವಾ ಡಿಫ್ರೆನ್ಸಿಯೇಷನ್ ನಿಂತಿದೆ ಅಂತ ನಾವು ಭಾವಿಸಕ್ಕಾಗಲ್ಲ. ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ನಾವು ಮಾಡ್ತೀವಿ. ಮತ್ ಕೊಡೋ ಅನುಕೂಲಗಳು ಕೂಡ ದುರುಪಯೋಗನೂ ಆಗ್ತಾ ಇದಾವೆ. ನಾನ್ ಮೊನ್ನೆ ಸನ್ಮಾನ್ಯ ಬನ್ನೂರ್ ಅವ್ರ ಹತ್ರ ಮಾತಾಡ್ತಿದ್ದೆ. ಅಟ್ರಾಸಿಟಿ ಕೇಸ್ ಕೂಡ ದುರುಪಯೋಗ ಆಗ್ತಾ ಇದೆ, 498A ಕೂಡ ದುರುಪಯೋಗ ಆಗ್ತಾ ಇದೆ. ಇದನ್ನು ಎಲ್ಲರೂ ನಾವು ನಿಗಾ ಇಡಬೇಕು. ಏನು ಗಾಂಧೀಜಿ ಅಥವಾ ಅಂಬೇಡ್ಕರ್ ಆಸೆ ಇಟ್ಕೊಂಡು ಯಾವ ಸೆಕ್ಟಾರ್ಗೆ ರಕ್ಷಣೆ ಇರಬೇಕು ಅಂತ ಒಂದು ಸ್ಥಿತಿನ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲಿ ತಂದು ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಒತ್ತು ಕೊಟ್ರು, ಅದು ಬಹಳ ದುರುಪಯೋಗ ಆಗೋ ಪರಿಸ್ಥಿತಿನೂ ಬಂದಿದೆ ಇವತ್ತು. ಆ ಕಡೆ ಕೂಡ ನಾವು ಗಮನ ಹರಿಸ್ಬೇಕಾಗಿದೆ. ಯಾರು ನಿಜವಾಗಿ ಶೋಷಿತರು ಅವ್ರಿಗೆ ರಕ್ಷಣೆ ಕೊಡೋದು ಆಡಳಿತದ ಮತ್ತು ಆಡಳಿತದಲ್ಲಿರೋರ್ದ ಜವಾಬ್ದಾರಿ ಆಗ್ಬೇಕಾಗತ್ತೆ. ಮೋಸ ಮಾಡಿ ಶೋಷಿತರು ಅಂತ ಡೋಂಗಿ ಹೊಡ್ಕೊಂಡು ಸುಮ್ನೆ ಕೇಸ್ ಕೊಡೋದು, ಸುಮ್ಗೆ ಯಾರಿಗೋ ಹರಾಸ್ ಮಾಡೋದು, ಇಂಥವು ಕೂಡ ಎಲ್ಲಾರು ಒಂದು ಸಣ್ಣ ಚೆಕ್ ಅನ್ನ ನಾವು ನಿರ್ಮಾಣ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಇಲ್ಲದೆ ಹೋದ್ರೆ ಎಲ್ಲದನ್ನು ದುರುಪಯೋಗ ಆಗುವಂತ ಪರಿಸ್ಥಿತಿ ಬಂದಿದೆ. ಹಾಗಾಗಿ ಇವತ್ತೇನು ನಾವು ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಕಮಿಷನ್ದು ಮತ್ತೆ ನಮ್ದು ಲಾ ಯೂನಿವರ್ಸಿಟಿಯವರು ಮತ್ತು ಕಿಲ್ಪಾನ್ ಅವ್ರದ್ದು ಇಟ್ಕೊಂಡು ಚರ್ಚೆ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಕಮಿಷನ್ ಇನ್ನೂ ಸ್ವಲ್ಪ ಸ್ಟ್ರಾಂಗ್ ಆಗ್ಬೇಕಾಗತ್ತೆ. ಯಾಕೆಂದ್ರೆ ಇನ್ನು ಅನೇಕ ರೂಪುರೇಷೆಗಳನ್ನ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ನಿಜವಾದ ಮನುಷ್ಯನಿಗೆ ಹಿಂಸೆ, ಕ್ರೌರ್ಯ, ಅವನ ತನಕ್ಕೆ ಅಗೌರವ ಇಲ್ಲಿ ಉಂಟಾಗುತ್ತೆ. ಅವನು ನಾನು ಈ ಭೂಮಿ ಮೇಲೆ ಹುಟ್ಟಿರೋದೇ ತಪ್ಪು ಅನ್ನೋ ಭಾವನೆ ಎಲ್ಲಿ ಬರ್ಬೋದು ಅಂತ ಅನ್ನೋ ಸ್ಥಿತಿ ಬರುತ್ತೆ. ಅದನ್ನ ನಾವು ತಪ್ಪಿಸ್ಲಿಕ್ಕೆ ಒಂದು ದೊಡ್ಡ ಪ್ರಯತ್ನ ಮಾಡ್ಲೇಬೇಕು. ಎಲ್ಲಾರು ಒಂದೇ, ಎಲ್ಲಾರ್ಗುನು ಒಂದೇ. ಯಾರಿಗೊಬ್ರಿಗೊಂದು ಇನ್ನೊಬ್ರಿಗೆ ಇನ್ನೊಂದು ಕಾನೂನು ಇದೆ, ಆಡಳಿತ ಇದೆ, ಶಕ್ತಿ ಇರೋರು ಏನ್ ಬೇಕಾದ್ರು ಮಾಡ್ಬೋದು, ಅಶಕ್ತರು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅನ್ನೋ ಸ್ಥಿತಿನ ನಿರ್ಮಾಣ ಮಾಡಿದ್ರೆ ಅದು ಸ್ವತಂತ್ರ ರಾಷ್ಟ್ರ ಅಂತ ನಾವು ಕರೆಯಕ್ಕಾಗಲ್ಲ, ಅದಕ್ಕೆ ಪ್ರಜಾಪ್ರಭುತ್ವ ಅಂತಲೂ ಕರೆಯಕ್ಕಾಗಲ್ಲ. ಒಬ್ರಿಗೊಂದೇ ಓಟು ಅಂತ ಮಾಡಿದ್ದು ಯಾಕೆಂದ್ರೆ ಎಲ್ಲರೂ ಸಮ ಅಂತ. ರೂಲ್ ಆಫ್ ಲಾ, ರೂಲ್ ಬೈ ಲಾ, ಮೊದ್ಲೇ ನಾ ಮಾತಾಡಿದ್ನಿ. ಇಟ್ಸ್ ರೂಲ್ ಆಫ್ ಲಾ ವಿ ಹ್ಯಾವ್ ಟು ಎನ್ಶೂರ್, ನಾಟ್ ರೂಲ್ ಬೈ ಲಾ. ರೂಲ್ ಆಫ್ ಲಾನ ನಾವು ಎನ್ಶೂರ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಯಾರು ಕಾನೂನಿಗಿಂತ ದೊಡ್ಡವರಿಲ್ಲ, ಯಾರು ಕಾನೂನಿಗಿಂತ ಮೇಲೆ ಇಲ್ಲ. ಕಾನೂನನ್ನ ಎಲ್ಲರೂ ಗೌರವಿಸ್ಬೇಕು. ಇಲ್ಲಾಂದ್ರೆ ಕಾನೂನು ಅದ್ರ ಕೆಳಗಡೆ ಏನು ಕ್ರಮ ಜರುಗಿಸ್ಬೇಕು ಅದನ್ನ ಜರುಗಿಸೋದು ಅನಿವಾರ್ಯ ಆಗುತ್ತೆ ಅನ್ನೋ ಸ್ಥಿತಿನ ನಾವೆಲ್ಲಾದ್ರೂ ಎನ್ವಿಸೇಜ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ, ಎಲ್ಲಾದ್ರೂ ನಾವು ಬಹಿರಂಗ ಪಡಿಸ್ಬೇಕಾಗತ್ತೆ. ಹಾಗಾಗಿ ಇವತ್ತೇನು ನಮ್ಗೆ ಮಾನವೀಯ ಹಕ್ಕುಗಳು ಕೆಳಗೆ ರಕ್ಷಣೆ ಇದೆ, ಅವುಗಳ ಸಂರಕ್ಷಣೆ ಕಡ್ಡಾಯವಾಗಿ ಆಗ್ಬೇಕಾಗುತ್ತೆ. ಅದರಲ್ಲೂ ಗ್ರಾಮೀಣ ಪ್ರದೇಶಗಳಲ್ಲಿ ಇದರ ಅರಿವು ಬಹಳ ಜನಕ್ಕೆ ಇಲ್ಲ. ಇದರ ಅರಿವನ್ನ ನಾವು ಯಾರಿಗೂ ಹೇಳಲಿಲ್ಲ. ಯಾರನ್ನಾರು ಅರೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್ ಪ್ರೊಸೀಜರ್ ಇದೆ, ಯಾರಿಗಾರು ಕಸ್ಟಡಿಗೆ ತಗೋಬೇಕಾದ್ರೆ ಏನ್ ಪ್ರೊಸೀಜರ್ ಇದೆ, ಇವತ್ತೂ ಗೊತ್ತಿಲ್ಲ. ಯಾರು ಬೇಕಾದ್ರೂ ಅರೆಸ್ಟ್ ಮಾಡ್ಬೋದು, ಯಾವ ಆಫೀಸರ್ ಯಾರನ್ನ ಬೇಕಾದ್ರೂ ಬೈಬಹುದು, ಯಾರನ್ನ ಹೆಂಗಾರು. ಈಗ ಅದರಲ್ಲೂ ನಾವು ಸಿಗಾಕೊಂಡ್ಬಿಟ್ಟಿದೀವಿ ರೈತರು. ಎಲ್ಲಾರು ನಮ್ಮನ್ನ ಅವರ ಈ ದೇಶದ ಆಳುಗಳು ಅಂತ ತಿಳ್ಕೊಂಡಿಲ್ಲ, ಅವ್ರ ಮನೆ ಆಳುಗಳು ಅಂತ ತಿಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈ ಕ್ರೌರ್ಯನ ನಾವು ತಪ್ಪಿಸ್ಬೇಕು. ಯಾಕೆಂದ್ರೆ ನಾನು ಹಿಂದೆ ಒಂದ್ಸರಿ ಮಾತಾಡ್ತಾ ಹೇಳ್ತಿದ್ದೆ, ಈ ಎಲ್ಲಾ ದೇಶದಲ್ಲಿ ಕೊಡೋನು ವೀರಭದ್ರ, ಇಸ್ಕೊಳೋನ್ ಕೊಡಂಗಿ, ಆದ್ರೆ ಇಲ್ಲಿ ಕೊಡೋನ್ ಕೊಡಂಗಿ ಇಸ್ಕೊಳೋನ್ ವೀರಭದ್ರ ಆಗ್ಬಿಟ್ಟು ಕಂಡ್ರಪ್ಪ ಅಂತ. ಯಾರೆಲ್ಲಾರ್ಗೆ ಕೊಡ್ತಾನೆ ಅವನನ್ನೇ ಕೊಡಂಗಿ ಮಾಡ್ಕೊಂಡು ನಡೆಸ್ತಿರುವಂತ ಪರಿಸ್ಥಿತಿ ನಮ್ಮ ರಾಷ್ಟ್ರದಲ್ಲಿ ಇನ್ನೂ ಇದೆ. ಇದಕ್ಕೆಲ್ಲಾರು ಒಂದು ಅಂತಿಮನ ನಾವು ಆಡ್ಬೇಕಾಗತ್ತೆ. ಇದನ್ನೇನಾರು ಒಂದನ್ನ ನಾವು ಒಂದ್ ಹಂತಕ್ಕೆ ತರಬೇಕಾಗತ್ತೆ. ಮನುಷ್ಯನಿಗೆ ಇರೋಂತ ಯೋಚನಾ ಶಕ್ತಿನ, ಅವನಿಗಿರೋ ಕ್ರಿಯಾಶಕ್ತಿನ ನಾವು ರಾಷ್ಟ್ರಕ್ಕೋಸ್ಕರ ಬಳಸ್ಕೋಬೇಕಾಗತ್ತೆ. ಅವನು ಯಾರ ಮನೇಲಾರು ಹುಟ್ಟಿರ್ಲಿ, ಯಾವ ಜಾತಿ ಇರ್ಲಿ, ಅವನಿ ದೇಶದ ಸ್ವತ್ತು ಮತ್ತು ಸಂಪತ್ತು ಅಂತ ನಾವು ಭಾವಿಸ್ಕೋಬೇಕಾಗತ್ತೆ. ಅಂತವ್ರನ್ನ ಎನ್ಕರೇಜ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ, ಅಂತವ್ರಿಗೆ ಸ್ವಲ್ಪ ಪುಷ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಯಾರು ಶಕ್ತಿನೇ ಇಲ್ದವನು, ಯಾರ ಅರ್ಹತೆನೇ ಇಲ್ದವನು ಎಲ್ಲದನ್ನ ಅನುಭವಿಸ್ತಾ ಇದ್ದಾನೆ, ಅವ್ನಿಗೆ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ, ಇಲ್ಲಪ್ಪ ನಿನ್ಗಿಂತ ಅರ್ಹ ಇನ್ನೊಬ್ಬ ಇದ್ದಾನೆ ನೋಡು ಅಂತೇಳಿ. ಮತ್ತೆ ಅವನಿಗೆ ಸ್ವಂತದಲ್ಲಿ ದುಡಿದು ಬದುಕ್ತೀನಿ, ಸ್ವಂತದಲ್ಲಿ ಏನಾದ್ರು ಗೌರವವಾದ ಜೀವನ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಪೂರಕವಾಗಿ ಪೋಷಕವಾಗಿ ನಾವು ಇರ್ಬೇಕಾಗತ್ತೆ. ಎಲ್ಲರನ್ನು ನಾವು ಸರ್ಕಾರದ ಸಪೋರ್ಟ್ ಅಲ್ಲೇನೆ ಅವರ ಸಹಾಯದಿಂದಲೇ ಮೇಲ್ ತರಕ್ಕಾಗಲ್ಲ. ಯಾರು ವೈಯಕ್ತಿಕವಾಗಿ ಮೇಲ್ ಬರ್ಬೋದು, ಯಾರು ವೈಯಕ್ತಿಕವಾಗಿ ಗೌರವಯುತವಾದ ಬಾಳ್ಬೋದು, ಅವ್ರಿಗೆ ನಾವು ಶಕ್ತಿ ತುಂಬಬೇಕು. ಮತ್ತೆ ಧರ್ಮಗಳು ಕೂಡ ಅಷ್ಟೇ. ಇಲ್ಲಿ ಯಾವ ಧರ್ಮನೂ ಹೆಚ್ಚು ಅಲ್ಲ, ಯಾವ ಧರ್ಮನೂ ಕಡಿಮೆನೂ ಅಲ್ಲ. ಎಲ್ಲಾ ಧರ್ಮ ಬೋಧನೆ ಮಾಡೋದು ಶಾಂತಿ ಜೀವನನೇ. ಶಾಂತಿಯಾಗಿ ಜೀವನ ಮಾಡ್ಬೇಕು ಅಂದಾಗ ಅವನ್ ಇಷ್ಟ ಬಂದಿದ್ದ ಧರ್ಮನ ಅವನು ಆಯ್ಕೆ ಮಾಡ್ಕೋತಾನೆ, ಅವನ್ ಇಷ್ಟ ಬಂದಿದ್ದ ಧರ್ಮನ ಅವನು ಪ್ರೊಫೆಸ್ ಮಾಡ್ತಾನೆ, ಅವನ್ ಇಷ್ಟ ಬಂದಿದ್ದ ಧರ್ಮದಲ್ಲಿ ಅವನು ಮದುವೆ ಆಗ್ತಾನೆ, ಅವನ್ ಇಷ್ಟ ಬಂದಿದ್ದ ಧರ್ಮನ ಅವನು ಮುಕ್ತಾಯ ಆಗ್ತಾನೆ. ಆ ಭಾವನೆಗಳಿಗೆ ನಾವು ಹೆಚ್ಚು ಒತ್ತು ಕೊಡ್ಬೇಕು. ಎಲ್ಲೋ 1%, 8% ಎರಾಟಿಕ್ ಫೆಲೋಸ್ ಬಿಹೇವ್ ಮಾಡ್ತಿರೋದನ್ನ ನಾವ್ ಇಡೀ ದೇಶದ ವ್ಯವಸ್ಥೆ ಅಂತ ಹೇಳಿ ಭಾವಿಸಕ್ ಆಗೋದಿಲ್ಲ. ಅವರಿಬ್ರಿಗೋಸ್ಕರ ಇಡೀ 98% ಆಫ್ ದಿ ಪಾಪ್ಯುಲೇಷನ್ ಅನ್ನ ಅವ್ರ ಅಧೀನದಲ್ಲಿ ಇಟ್ಟು ಜೀವನ ಮಾಡ್ಸಕ್ ಆಗೋದಿಲ್ಲ. ಹಾಗಾಗಿ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ನಾವು ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ ಏನಿದೆ ಇದಕ್ಕಿನ್ನೂ ಹೆಚ್ಚು ಒತ್ತಾಗಿ ಕೆಲಸ ಮಾಡಬೇಕು. ಇದಕ್ಕಿನ್ನೂ ಹೆಚ್ಚು ಒತ್ತಾಗಿ ನಾವು ಈ ರಾಷ್ಟ್ರದಲ್ಲಿ ಶಕ್ತಿ ತುಂಬಬೇಕು ಅಂತ ಹೇಳಿ ನನ್ನ ಅಭಿಪ್ರಾಯ ಇದೆ. ಆ ಕಡೆ ಹೆಚ್ಚು ಆಲೋಚನೆಗಳನ್ನಾಗ್ಲಿ. ಒಳ್ಳೆ ಕೆಲಸ ಇವತ್ತು ಲಾ ಯೂನಿವರ್ಸಿಟಿ ಅವರ ಸಂಯೋಜನೆಯೊಂದಿಗೆ ನಮ್ಮ ದ್ವಾರಕನಾಥ್ ಬಾಬು ಅವ್ರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಬಾಬು ಯಾವಾಗ್ಲೂ ಬಹಳ ಕ್ರಿಯಾಶೀಲವಾದ ವ್ಯಕ್ತಿ. ನಮ್ಮ ಸೆಕ್ರೆಟರಿ ಆಗಿ ಪಾರ್ಲಿಮೆಂಟ್ ಅಫೇರ್ಸ್ ಅಲ್ಲಿ ಇದ್ದಾಗಿಂದ ನಾವು ನೋಡ್ತಿದ್ದೆ. ವಯಸ್ಸಾಗಿದೆ ಅವ್ರಿಗೆ, ಶರೀರಕ್ಕೆ, ಮನಸ್ಸಿಗಿನ್ನೂ ಸ್ವಲ್ಪ ಉರ್ಪಿದೆ. ಆ ಉರ್ಪನ್ನ ಇನ್ನೂ ಚೆನ್ನಾಗಿ ಬಳಸ್ಕೊಳ್ಳಿ. ಇಂಥ ಅನೇಕ ಕಾರ್ಯಕ್ರಮಗಳು ಆಗ್ಲಿ. ಮತ್ತೆ ನಮ್ಮೆಲ್ಲ ಸ್ಟೂಡೆಂಟ್ಸು ಇದ್ರಲ್ಲಿ ಹೆಚ್ಚು ಇನ್ವಾಲ್ವ್ ಆಗ್ಬೇಕಾಗತ್ತೆ. ನಾನು ಒಂದು 3-4 ವರ್ಷದಿಂದ ಈ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಬಗ್ಗೆ ಬಹಳ ಒಳ್ಳೆ ಭಾಷಣ ಒಂದು ಫಸ್ಟ್ ಗ್ರೇಡ್ ಕಾಲೇಜಲ್ಲಿ ಮಾಡಿದ್ದೆ. ಅವತ್ತು ನಮ್ಮ ನಾಗಮೋಹನ್ ದಾಸ್ ಅವರು ನನ್ನ ಜೊತೆ ಇದ್ರು, ಜಡ್ಜ್ ಅವರು. ಅನೇಕ ಮಕ್ಕಳು ನನಗೆ ಹೇಳಿದ್ರು, ಸರ್ ಇವೇನು ನಮಗ್ ಕಲ್ಪನೆನೇ ಇರ್ಲಿಲ್ಲ ನೀವು ಬಂದು ಮಾತಾಡೋರ್ಗು ಅಂತ ಹೇಳಿ. ಹಾಗಾಗಿ ಅವತ್ತು ಒಳ್ಳೆ ತಯಾರಿಲಿದ್ದೆ ನಾನು. ಇವತ್ತು ಅಷ್ಟೊಂದು ತಯಾರಿಲಿಲ್ಲ, ಟು ಸೇ ಸಾರಿ. ಬಟ್ ನಾವು ಮಕ್ಕಳಿಗೆ ಬದುಕೇನು, ಬದುಕಲ್ಲಿ ಎಲ್ಲರೂ ಹೇಗೆ ವರ್ತಿಸ್ಬೇಕು, ಭಾವಿಸ್ಬೇಕು, ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕು, ಮತ್ತೆ ಬದುಕಲ್ಲಿ ಅವಕಾಶಗಳನ್ನ ಹೆಂಗೆ ಸೃಷ್ಟಿ ಮಾಡ್ಕೊಡ್ಬೇಕು. ವಾಟ್ ಈಸ್ ಸೋಷಿಯಲಿಸಮ್? ಸೋಷಿಯಲಿಸಮ್ ಈಸ್ ಪ್ರೊವೈಡಿಂಗ್ ಈಕ್ವಲ್ ಆಪರ್ಚುನಿಟಿ ಟು ಆಲ್. ಅಷ್ಟೇ, ಎಲ್ಲರಿಗೂ ಸಮಾನವಾದ ಅವಕಾಶಗಳನ್ನ ಕಲ್ಪಿಸ್ಕೊಡೋದು ಒಂದೇ ಸಮಾಜವಾದ ಬಿಟ್ರೆ ಬೇರೆ ಏನೇ ಇಲ್ಲ. ಹಾಗಂತ ನಾವು ಒಬ್ಬರನ್ನೊಬ್ರು ತುಳಿದೊಬ್ರ ಮೇಲೆ ಬರೋದಲ್ಲ. ಒಬ್ರೊಬ್ರು ಪೈಪೋಟಿನಲ್ಲಿ ಮುಂದೆ ಬರೋದನ್ನ ಯಾವ ಸಮಾಜನೂ ಅಡ್ಡಿ ಮಾಡಲ್ಲ. ತುಳಿತಕ್ಕೊಳಗಾಗೋದನ್ನ ನಾವು ತಪ್ಪಿಸುವಂತ ಕೆಲಸಗಳು ಮಾಡೋ ಕಡೆ ನಮ್ಮ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಕಮಿಷನ್ ಇನ್ನೂ ಹೆಚ್ಚು ಕೆಲಸ ಮಾಡುವಂತ ಸ್ಥಿತಿ ಬರ್ಲಿ. ಅವ್ರ ಜೊತೆ ನಾವಿದ್ದೀವಿ. ಅವ್ರಿಗೆ ಏನೇನು ಸಹಾಯ ಬೇಕು, ಅವ್ರಿಗೆ ಸರ್ಕಾರದ ವತಿಯಿಂದ ಏನೇನು ಇನ್ನೂ ಶಕ್ತಿ ತುಂಬಬೇಕಾಗಿದೆ, ಆ ಕೆಲಸ ನಾನು ಮಾಡ್ತೀನಿ. ಈಗಾಗಲೇ ಬನ್ನೂರ್ ಮಠ್ ಸಾಹೇಬ್ರಿಗೆ ನಾನು ಹೇಳಿದ್ದೀನಿ. ಆ ಕಡೆ ಲಾ ಮಿನಿಸ್ಟರ್ ಆಗಿ ನಾನು ಹೆಚ್ಚು ಒತ್ತು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ, ಈ ದಿಕ್ಕಲ್ಲಿ ಕಮಿಷನ್ ಇನ್ನೂ ಚೆನ್ನಾಗಿ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಆರಂಭ ಮಾಡ್ಲಿ. ಸ್ವಲ್ಪ ಜಿಲ್ಲಾ ಮಟ್ಟ, ತಾಲೂಕು ಮಟ್ಟದಲ್ಲಿ ಅವರು ಅವರ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಅನ್ನ ಶಕ್ತಿಯುತ ಮಾಡ್ಕೊಳ್ಳಿ. ಸೋರ್ಸ್ ಆಫ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಬರುವಂತ ಸ್ಥಿತಿ ಕೂಡ ಅವರೇ ಇಟ್ಕೋಬೇಕು. ಎಲ್ಲಾದ್ರೂ ವೈಲೇಷನ್ ಆಗ್ತಾ ಇದೆ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಅಂದ್ರೆ ಯಾರಾದ್ರೂ ಅವ್ರಿಗೆ ಹೇಳುವಂತ ಪರಿಸ್ಥಿತಿನ ಇಟ್ಕೊಳ್ಳುವಂತ ಸ್ಥಿತಿ ಬರ್ಲಿ. ಅದಕ್ಕೆ ಪೂರಕವಾಗಿ 2, 3, 4 ನಮ್ಮ ಸರ್ಕಾರಿ ಆಡಳಿತದಲ್ಲಿ ಅಥವಾ ಇಲಾಖೆಗಳನ್ನು ಕೂಡ ಬೇಕಾದ್ರೆ ಅವರು ಬಳಸ್ಕೊಳ್ಳಿ. ಅದಕ್ಕೆಲ್ಲ ನಾವು ಶಕ್ತಿ ತುಂಬ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಬಹಳ ಹರ್ಷವಾಗಿ ನಾನು ಇದನ್ನ ಸಂಘಟನೆನ ಸ್ವಾಗತಿಸ್ತೀನಿ. ಮತ್ತೆ ಈ ಕಾರ್ಯಕ್ರಮನ ಉದ್ಘಾಟನೆ ಮಾಡಿದ್ದೀನಿ. ಒಳ್ಳೆ ಚರ್ಚೆ ಆಗ್ಲಿ. ಇದರಿಂದ ಎಲ್ಲ ಕಾನೂನು ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಮತ್ತು ಕಾನೂನನ್ನ ಬೋಧನೆ ಮಾಡೋರ್ಗೆಲ್ಲ ಸ್ವಲ್ಪ ಅರಿವು ಜಾಸ್ತಿ ಆಗ್ಲಿ. ಅರಿವೇ ಶಕ್ತಿ ಅನ್ನೋ ಮಾತನ್ನ ಹೇಳ್ತಾ ನನ್ನ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಕರೆದು ನನ್ನ ಜೊತೆಯಲ್ಲಿ ಕಾನೂನು ಮಾಡಿಕೊಟ್ಟ ದ್ವಾರಕನಾಥ್ ಬಾಬು ಅವ್ರಿಗೆ ಮತ್ತೆ ನಿಮ್ ಯೂನಿವರ್ಸಿಟಿ ಅವ್ರಿಗೆ, ನೀವೇನೋ ಬಹಳ ನನ್ನ ಬಗ್ಗೆ ಒಳ್ಳೆ ಮಾತನಾಡಕ್ ಶುರು ಮಾಡಿದ್ದೀರಿ. ನಾನು ಅಷ್ಟೊಂದೇನು ಮಾಡಿಲ್ಲ ಯೂನಿವರ್ಸಿಟಿಗೆ. ಆಸ್ ಎ ಮ್ಯಾನ್ ನಾನ್ ನಿಮ್ಗೆ ಏನಾದ್ರು ಹಿಂದೆ ನಿಂತ್ಕೊಂಡು ಮಾಡ್ಲಿಕ್ಕಾದ್ರೆ ಖಂಡಿತ ನಿಮ್ ಜೊತೆ ನಾನು ಇದೀನಿ ಅನ್ನೋ ಭಾವನೆ ಇಟ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾ ನಿಮ್ಗೆಲ್ಲ ಆಭಾರಿ ಅಂತ ಹೇಳಿ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತೀನಿ. ನಮಸ್ಕಾರ, ವಂದನೆ. ಹೇಳಿ ಬಾಬು.
ಬಹಳ ಧನ್ಯವಾದಗಳು ಸರ್.
ಯಾಕೆ
ಮಾಡ್ಕೊಂಡು ಈ ಸೆಷನ್ ಉದ್ಘಾಟನೆ ಮಾಡಿ ಬಹಳ ಧನ್ಯವಾದ ಸರ್. ಥ್ಯಾಂಕ್ ಯು.
Thank you so much, sir. May I request Dr. Rajendra Kumar Hittangi, Assistant Professor, KSLU's Law School, to kindly introduce the resource person for the first session, Honorable Mr. Justice S.R. Banurmat. Please, sir.
Good morning to all the dignitaries and the participants. It's my privilege to introduce our resource person of the first session to speak on history of human rights and human rights institutions, Honorable Mr. Justice S.R. Banurmat. Sir was born on 23rd January 1948 at Dharwad. After completion of graduation in science at RL Science College, Belgavi, Sir joined Raja Lakamgowda Law College, Belgavi for his LLB degree and also University College of Law, Dharwad. Enrolled as an advocate on the role of Karnataka State Bar Council on 28 March 1973 and started practice at Belgavi District Court under senior advocate late Sri D.T. Mule. In 1974, shifted practice to High Court of Karnataka at Bangalore by joining the office of Sri K. A. Swami, who was later elevated to bench in 1979 and retired as a Chief Justice of Tamil Nadu. In 1979, Sir started independent practice, dealing in all branches of laws, specializing in civil, criminal, and constitutional cases in Karnataka High Court, and also appeared regularly in Supreme Court of India. Considering early achievements and outstanding merit, especially in criminal law in 1990, he was the youngest advocate to be appointed as state public prosecutor and government advocate, and continued till June 1997 in spite of change of 4 governments and 5 advocate generals. Sir was elevated to the bench of Karnataka High Court as a judge, and he assumed the office on 11th June 1997. Between 1997 to 2009, rendered thousands of judgments in all branches of law. Considering his lordship's vast knowledge and expertise in criminal law as a defense advocate and as a state public prosecutor, majority of times he was assigned with the major criminal cases, both as a single judge and in division bench. Rendered hundreds of landmark judgments in criminal law, giving new dimensions to criminal justice system, safeguarding interest of accused as well as victims and the society. He assisted Justice V.S. Malimat, Commission on Reforms on Criminal Justice System, especially on victimology. Landmark judgments include 5 death penalty judgments. Noted amongst them are Swami Shraddhananda case and psychopath serial killer Umesh Reddy. In an acid throwing case known as a Hasina case for the first time in India, even after the accused had undergone imprisonment and out of jail, noting the heinous nature of the crime, Sir ordered the accused to undergo imprisonment for life with a compensation of ₹2 lakhs to the victim. At the same time, considering plights of such victims in general, directed the government to implement a scheme framed by him for such acid victims, including medical and minority health, rehabilitation, etc. As per the direction of the Supreme Court, he was the designated judge to monitor mental health of citizens of Karnataka and issued numerous directions in bringing awareness and importance of mental health in society. Sir monitored mental health institutions, including renovations of mental health institute like Dharwad, which is today known as one of the best mental health institutes serving needy people of the North Karnataka. Sir was also initially a member and later chairman of Court Computerization Committee, an initiative of the Karnataka High Court. Karnataka High Court was the first High Court in India to develop its own operating system to manage the entire court procedure like filing, scrutiny, certificate copies, etc. This resulted in reducing pendency and increasing efficiency of court management to reduce pendency of cases to a large extent. Sir was the first judge to introduce evidence recording through video conferencing. First time in India, Sir was also, he introduced a video conferencing system in all prisons in the state. As a founder president of Bangalore Mediation Center, Sir was invited to USA by Justice Department of America. He, along with team of judges, held discussions with major institutions like Warner Brothers, Microsoft, General Motors, and Stanford University on intellectual property rights issues concerning US and India. Sir was elevated as the Chief Justice of Kerala in 2009 and retired on 22nd January 2010. Though his tenure as a Chief Justice in Kerala was hardly 1 year, because of his integrity and uncontroversial nature and his efforts to improve the justice delivery system with innovative ideas, earned him a good name, and he was acclaimed by one and all as only the second best Chief Justice after Dr. Justice V.S. Malimat Kerala has ever seen. To bring transparency in judiciary, Sir was the first Chief Justice in India who declared his assets along with all judges of Kerala High Court and posted on website of Kerala High Court in September 2009. He also established the first green branch to protect environment and biostructure of Kerala. In fact, on the date of his retirement, late Justice Sri V.R. Krishna Iyer, former Supreme Court judge, acclaimed, the jurist of international, he's a jurist of international repute, wrote thus: to honor the great Chief Justice Banurma, Chief Justice of Kerala, I join you to pay homage to that high noble functionary. He was a great judge, and the qualities of a good justice, in the words of Socrates, run thus: four things belong to judge: to hear courteously, to answer wisely, to consider soberly, and to decide impartially. These were the words spoken of our Justice Banur. In 2013, he was appointed as the chairperson of Maharashtra State Human Rights Commission, Mumbai, and he demitted the office in January 2018 on completion of 70 years as per the law. Sir presently appointed as the chairman of the Law Commission of Karnataka, and he assumed the office of chairman on 20th September 2019. Sir has also held so many positions, and he acted as a chairman of Expert Committee on Advanced Center of Cyber Laws and Forensic Science. See, sir is also chairman of prestigious institutions like BMS Education Trust, Bangalore. Like that, we are really lucky to have you, to have such a personality to deliver a lecture on human rights institutions. Sir, thank you very much for accepting our invitation. Now I hand over to you, sir. Sir, please.
Honorable Law Minister Shri Madhuswamiji, who is also Pro-Chancellor of Karnataka Law University, Professor Ishwar Bhatt, the Vice Chancellor, Shri Dwarkanath Babu, President of today's function, who is the Director of Kilpar, all the faculties of Karnataka Law University, many of us, I know you personally also, like Professor Chidanand, Professor Ratna Baramgodar, Professor Patil, and others. And most importantly, my dear student friends. Today's selection of subject is most necessity, as Honorable Law Minister said. It's the fundamental rights and human rights which are order of the day, which to be looked into. Every one of us in our day-to-day life talk or ascertain about our rights, whether justifiable or not. We always say, I have got this right to do what I want or what I like. Recent example, during this pandemic, when the government and the medical experts suggested to wear mask, keep distance, many people, including the so-called educated persons, said, no, I have right to whether wear or not. You can't force me to do those things. So we have to find out what exactly are the rights of human beings, whether they are unbridled or without control, or also how to enforce them legally and peacefully. So today, I am going to speak on basically history of global human rights movement, the law and the human rights protection institutions in India, and briefly about the law itself. Now, concept of human rights has undergone a long process of evolution. We, the human beings, are always say that, immensely proudly say, that we are the most intelligent and rationally thinking animals in the entire universe. Unfortunately, unlike all animals which fight and kill other animals only for food or self-protection of herds, especially young ones, we, the human beings, require no such legitimate reasons. We take pleasure in harassing others, fight for flimsy reasons, or even injure or kill fellow human beings. A few years back, during one of my trips abroad, As a zoology student, I was very much interested in seeing the various zoos and see the animals. In one of those trips of zoos, which is a very at San Diego, I think, in United States, one of the best and biggest zoo in the world. All animals of all world, entire universe are there, live or stuff. And it takes about 4 hours to go around. And they have also arranged a small train like which moves around and takes you. Now, while going inside, I toured the entire thing. And then just before the end of the tour, there was one big premises with a board. See the wildest animal in the world, wildest and cruelest animal in the world at your risk. So being curious, I knew many of the, as a zoology student, which are the cruel animals. So I entered the premises. So again, there was a board, enter at your risk. So I said, fine, let me go inside. And there was a curtain. And when I went inside, there was a big mirror. And I could see myself. That is to indicate that man is the most cruelest animal in the world. Dr. Sarvapalli Radhakrishnan, a great philosopher and second president of India, has said, no wild beast is more destructive or crueler to man than his own fellow human beings. Right from the ancient times, there are operations and separations of human beings by human beings themselves. This has led to struggle and revolution of protecting human rights. Ladies and gentlemen, though for the human rights protection movement, modern historians give credit to Magna Carta of 1215 AD and to American Declaration of Independence in 1776, French Revolution, etc., which is followed by many other Western concepts. We, the Indians, must be proud to say that before Western concept of human rights came into existence,
Honorable Justice sir. Hello, sir. Hello, you are muted, sir.
Yeah.
Kindly unmute, sir.
Yeah.
Yes, please, sir. Yeah, now I can hear. Yes, please.
The Rigveda, as I said, all human beings are equal, all are brothers and sisters. This in turn gave the concept to the world, Vasudhaiva Kutumbakam and Vishwa Bandhutva, which is in modern terms known as universal brotherhood and concept of global village. Similarly, in Atharva Veda, we find a proclamation that all human beings are equal and have equal right over food and shelter. We must remember the ethos of this great nation is Om Sarve Bhavantu Sukhina, Sarve Santu Niramaya, Sarve Bhadrani Pashyantu, Ma Kaschid Dukkham Bhagavavet. To translate it roughly, may all be happy, may all be free from illness, may all see what is auspicious, and may no one suffer. In my view, the concept of human rights was this basic ethos of this country. The concept of human right was in existence since ancient time, as I said, in India, even when most of the other parts of the world were in pre-civilization state. But internationally, the global movement, what is called as global movement, started only after 2 world wars in 1914 to 1918 and 1939 to 1945. A true codified uniform structure was to be given for protection of human rights, the wars were responsible. The destruction of both human beings and properties, and especially torture of war prisoners and people of occupied nation led by nations, brought nearly 51 nations, today of course the number is 194, of world leaders and thinkers together. And this resulted in establishment of United Nations Organization or UNO. Now it is ironic that Adolf Hitler, who was responsible for the genocide and terror and violence and genocides of thousands of men, women, children, whom he called as belonging to impure race. And this genocide itself brought awakening of the conscience of mankind to take measures to oppose, to prevent the barbaric acts and inhuman violences and violations of human rights. We must thank Adolf Hitler in that sarcastic way. Now, the General Council of United Nations held many meetings, and ultimately on 10th December 1948, a historic document was born and adopted by United Nations in its 183rd Assembly session at Paris, which is, as I will refer, Universal Declaration of Human Rights or UDHR. In its preamble itself, it is said, whereas recognition of inherent dignity and of the equal and inalienable rights of all members of human family is the foundation of freedom, justice, and peace in the world. It is to be noted that UDHR promised and proclaimed to all human beings all the economic, social, political, cultural, and civic rights which are inalienable to people without discrimination as to the gender, caste, nation, or ethnic groups. In this sense, true international human rights movement took birth on 10th December 1948, and that is why this day, that is 10th December, is celebrated all over the world as International Human Rights Day. But human rights abuses did not end when UDHR was adopted. But since then, countless people all over the world have gained greater freedoms. Violations have been prevented, apartheid lessened, but still it is continued. The independence, autonomy have been given to many countries because of these human rights issues. Though many nations did not treat this Universal Declaration as legally binding, the preamble itself states, whereas it is essential if man is not compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human right should be protected by the rule of law. Though many of the Supreme Court judgments, both Indian and American, they say that this is, though this is not, the UDHR is not binding, it is still to be treated as a rule of law. The Universal Declaration, original one, had 30 articles proclaiming various human rights, affirming individual rights, although not legally bound in themselves. And these have been elaborated in subsequent international treaties and regional human rights laws and national constitutions. Now, so far as India is concerned, who is one of the signatory to this UDHR UN declaration, again, we were much ahead of the world in this regard. Immediately after our independence in 1947 itself, the Constitution Assembly of India, of which great stalwarts and scholars like Dr. Ambedkar, Aladi Krishnaswamy, K.M. Munshi, and others were members, drafted and adopted a greatest document on earth, which I call as the greatest document on earth, that is the Constitution of India, which came into force on 26 January 1950. This is one of the monumental documents in the history of human beings. Now, in this Constitution, it is declared, the preamble itself says, India is a sovereign, socialist, secular, democratic republic, assuring, this is important, assuring its citizens justice, equality, and liberty. Ladies and gentlemen, the Constitution of India has incorporated most of the human rights enshrined in the Universal Declaration of Human Rights as fundamental rights. Now, Honorable Minister was mentioning about the fundamental rights, which are the preamble itself reflects the basic philosophy of human rights by promising to secure all its members and citizens justice, that is social, economic, and political, then liberty of thoughts, expression, belief, faith, and worship, equality of status and opportunity. Now, only at this stage to the students, I would like to mention, though fundamental rights and human rights are almost similar, there is this little demarcation between the fundamental rights and human rights. The Constitution provides some of the fundamental rights can be curtailed by law or due process of law, but human rights are uncurtailable. Now, it cannot be, I will go into the detail, what is the this one. But there is a slight difference between human rights and fundamental rights. But for this small difference, they are all the same. That's why I said, much before the Universal Declaration was born, India had considered and made them, almost many of them and most of them, as fundamental rights. Now, on international level, coming back to, after several conventions and meetings of United Nations, especially in Geneva and Paris, it was felt that each member country should have its own law on protection of human rights, because Universal Declaration is not to be, was considered to be not binding on countries. So the convention came in Geneva, held in Geneva and Paris, that decided that member countries should have their own law on protection of human rights. Now, accordingly, India decided to enact a special law known as Protection of Human Rights 1993. Now, this act created two institutions for protection of human rights. One at the national level, called as National Human Rights Commission, and other at all state levels, called as State Human Rights Commissions. Many of us are not aware what exactly is human right, or how it is to be protected under the law. Let me state that basically human rights by their very nature constitute the minimum right that are necessary for a human being to live in a civil and political society as a free individual with dignity and respect. ಮಾನವನು ಮಾನವನಾಗಿ ಸ್ವಾತಂತ್ರ್ಯದಿಂದ ಬದುಕುವ ಹಕ್ಕು. This is the simplest meaning. That is, right of every human being to live like a normal human being with dignity and liberty. This is the basis of human rights. Now, these human rights come by birth, nobody gives them or nobody can take them away. These are all universal. This is again small difference between our constitution of fundamental rights and human rights. Constitutional rights, most of them are available to the citizen of India. But as I said, human rights are universal and not confined to any country, race, creed, sex, or religion. As I was referring to the original UDHR, there were 30 human rights declared under this universal declaration, like anti-slavery, forcible occupation of a country by war, protection of war prisoners, etc. Now, with the passage of time and getting awareness, the scope and applicability of the human rights has grown to vast extent. Thanks to the debates and especially various landmark judgments of the Honorable Supreme Court. Today, the basic concepts have expanded, creating newer rights. I must mention here itself the fundamental right, Article 21, which I always call as a mother of human fundamental rights, which is also known as the right to life, is the fundamental right guaranteeing, the human rights. Now, though initially the scope of Article 21 was somewhat restricted, today it has expanded to newer rights, similar to the, parallel or equal to the human rights, like right to information, right to education, senior citizens' rights, rights of disabled, then rights of pollution-free environment, and palliative care. Now, this is the newest edition. It's a palliative care. Now, for the information of the students, many may not know what is the palliative care. Palliative care is the care of the person who is terminally ill, like cancer or a failure of kidneys. There is no hope for living for him. Now, in such conditions, it is well known that a lot of money is required to treat these patients. Huge amount of money is required to the patients. And more importantly, this is causing heavy burden on the families as well as mental pressure. They have to fight for the living, the treatment of that relative or person. But the burden cast upon them mentally and physically is very heavy. And that's why this palliative care was introduced. Palliative care is nothing but taking care of not only the patients, but mainly of the family of the patients. Many institutions are there in India now. Of course, I'm one of the patrons of Maharashtra institution called as Care India. There are many in Bangalore also. There they help the family, not necessarily monetarily, but also give mental support to them, to tell them, we are here to care for you and your patient. They give medical help also sometimes, but of course, there are certain restrictions because most of the drugs, especially, are opium-based. Now, so this is the scope of 30 articles in Universal Declaration has expanded to such an extent that it is under the sky, everything is your right. Of course, it must be legitimate right. It should not be illegal right. One cannot have right to commit a murder or commit a theft. Say the person committing theft may say that it is my right, my profession. No, it must be as long as it is legal. within the basic fundamental rights, Article 21, etc., it is to be looked into. Now, as I was saying, the law is expanding. The definition of human rights is expanding. While I was in Mumbai, I just give an instance. While I was in Mumbai as a Human Rights Commission chairman of Maharashtra, I came across a case where a woman complained to the Human Rights Commission that her daughter, a young girl, was missing and the police had not taken any action. And then it was found out that though she gave complaint properly of a missing person, young girl she was, missing complaint of a daughter, the police registered a case and then took no action. Unfortunately, though, on the very next day of giving complaint, a dead body of girl was found in nearby area. Police did not take any steps to get identified the dead body, what is the name or whom to she belongs, or any efforts to find out whether the girl, there is any missing complaint, etc. Now, after some time, almost after a month, she came to know that somewhere that there was a dead body found at or etc. She went to the police station and identified from the photograph and clothes that it was her daughter. When she approached, she said mainly her grievance was against the police. Then there was a question as to whether what is the violation of human rights. Yes, it is the duty of the police to register complaint. It is the duty of the police to investigate. No, but the definition of violation of human rights was mainly, which was worrying me. And so we declared that there are two violations of human rights. One is human right of the family, especially of the mother, although husband was not, a father was not there, and her relatives, seeing for the last time the face of a dead person. Of course, this is again now under debate due to the corona pandemic. Secondly, the right of dead person to get last rites performed according to the custom or family relations. Now, of course, how much this is relevant now, because we have seen last Delta pandemic, what are the effects going on and how bodies had to be disposed of. But nevertheless, there were instances all over India, it was shown on media that dead bodies were handled very casually and not properly. See, according to me, the dead also have a right to be given last rites properly. Now, there is no day further time we may have good governance as human rights. As we have a right to elect our representative, right to vote and right to elect our representative, if there is no governance, voter has a right to recall the representative or at least ask for good governance. Now, it is not yet born, but it may come slowly. Now, coming back to the institutions under the our Human Rights Protection of Human Rights Act. Those two institutions are statutory bodies and they are to maintain its independence. The Act provides certain mandatory provisions. The Commission at the national level consists of a chairperson and members. At national level, Commission chairman must be a former Chief Justice of India, Supreme Court of India. Now it is a little bit amended. Even the judge, Chief Justice of a state can also be. Whereas at state level, it is former Chief Justice of a state who can alone be qualified to be considered as chairman. Of course, there is again amendment recently that a judge of High Court can also be considered for the chairmanship. Now, National Human Rights Commission has 4 members, out of whom one is former or sitting judge of Supreme Court, 1 member from former Chief Justice of a High Court, and 2 members among persons having experience or knowledge relating to human rights. I will call it a short, NHRC also has other members, there's co-opted members, like chairperson of different national commissions, like minority commissions, SC/ST commissions, women and children commissions, etc. Now, at the state level, the State Human Rights Commission, the chairperson is former Chief Justice, and there are only 2 members earlier. One must be a from judiciary, that's either former High Court judge or district judge, and second member, a person having experience or knowledge, specialized knowledge of human rights. Presently, as per the amendment, the chairman can be retired Chief Justice or retired judge, and there is an amendment also now to include 1 woman member mandatorily as member of the Human Rights Commission. Now, both commissions have a secretary of IAS grade, who is the Chief Executive Officer. To keep the high standards and functioning of these commissions, selection procedure of the commission members, chairman, etc., is very strict. At national level, there is an appointing committee consisting of Prime Minister, speakers of Lok Sabha, Deputy Chairman of Rajya Sabha, leaders of opposition of both the houses, and the Home Minister also. Only on the recommendation of this committee, the President of India appoints the chairman and members of National Human Rights Commission. Similarly, at state level, the appointing committee consists of Chief Minister, speakers of both the houses, Home Minister, and leaders of opposition. Now, the initial term of the office for chairperson and the members is 5 years or up to 70 years of age, whichever is earlier. Now, I'm told that it is 5 years is reduced to 3 years. Now, so far as members are concerned, they are eligible for reappointment for further 3 years, but not the chairperson. Now, they keep the dignity of this statutory body. The salary and other perks are equivalent to Chief Justice and Judge of a High Court, respectively. Now, there are other officials which are important, which I call as important wings of the Human Rights Commissions. Of course, first is the administration wing, which is headed by an administrative officer. And as I already mentioned, the CEO is an IAS officer to look into the administration. Now, there is another wing called as legal wing, which is headed by a judicial officer of district judge level, cadre, who is normally termed as the registrar of the Human Rights Commission. Now, under him, there are 2 law officers, many law officers who help him in this his day-to-day work as the legal wing head. Now, third wing is the important wing is investigation wing, which is headed by Director General of Police or IGP working. I will give detail. I will tell you each function of these wings separately. Now, the central or state government allocates the annual budget, the necessary grants to these commissions. Now, what are the functions of this commission. Section 12 of the commission of the Protection of Human Rights Act gives the functions, what are the functions of these commissions. Both are same at the national and state level. The basic duty of the commission is to inquire into complaints of victims of violation of human rights by any public servant. Please note for students, this is only against complaints against any public servant. And this public servant has been defined under section 21 of the Penal Code. Why I am emphasizing on this any public servant? People feel that though there is an institution called as human right, protection of human rights, for the protection of human rights, why we are not getting access to this Human Rights Commission? Now, the functioning or the power of the Human Rights Commission is confined to violation of human rights by any public servant. Every day, as I said earlier, every day in and out, there are violations of human rights. Now, if husband slaps a woman, his wife, that's a violation. If there is a theft in my house, security, which is security, is my fundamental right, I mean human right. Now, for all these things, there is no public servant directly involved in a violation, directly. For these other things, there is a machinery created under different laws. CRPC is there, IPC is there, different acts of penal provisions are there. The people can go take a recourse under those acts. But if there is a violation of human rights by any public servant, it is only the Human Rights Commission which comes directly into picture, which has got power to exercise and give proper directions. Now, it should not be understood that public servants means only the state government or the machinery under the state government or entire state government. It also includes local bodies like municipal corporation, Zilla Panchayat, or any institution which runs by getting major grants from the government. They all come within the purview of definition of public servant as defined under section 21 of the Indian Penal Code. Now, any violation of human rights by these public servants come within the purview of the commission. At this stage itself, I would like to mention that procedure for giving complaints to the commission is very, very simple and without any hassles, unlike the courts. There is no strict format under which you should give complaint. You just write a letter. Many times in Mumbai, every day I used to get complaints written on a torn page of notebook of a child, children, school notebooks. See, there is no format at all that it must be addressed in this way. Only they have to bring it to the notice of the commission. There is violation of human rights by certain official or officers. The second important advantage is it is totally cost-free. No fee at any stage is required to be paid by the complainant. At any stage, right from the beginning of giving the complaint till the end, till he receives the copy of the order, either accepting it is a violation or not, this whole thing is totally cost-free. Now, how the procedure starts? On receipt of the complaint, a case number is generated and the matter is sent to legal cell of which the district judge is a registrar, for scrutiny as to whether the case is to be considered as maintainable or not. And thereafter, the same is placed before the chairman or the member to finally say the maintainability. The final decision of the commission is always that of chairman or the members, whether to accept the case or not. Now, why I mentioned is maintainability. As I said earlier, there are so many violations and so many complaints every day you get in human rights commissions. Nearly, I was getting nearly 100 to 150 complaints every day. Now, these are, my husband is beating me, he is not looking after me, or my brother is not giving me share, etc. Now, as there are other remedies available, and they are the violations of human rights by individuals, not public servants, they are not maintainable. So those scrutiny is made, and only which are against the public servants, and where there is some prima facie case of violation, they are accepted. Now, once the complaint is maintainable and accepted, the commission calls for a report from the concerned public servant or the department concerned, informing them or him that there is such a complaint against you of violation of human rights, and what do you say? Now, sufficient time is given to them, and on receipt of the report, the chairman or the member looks into both complaint and report and scrutinizing it, and if satisfied that the reply given by the concerned public servant is justifiable and there is no merit, it can close the case. You must remember, unlike the criminal courts, the complainant is always kept informed at every stage in human rights commissions. If a case is to be rejected, he will be informed. He may file his reply also or additional material also. Then, if we want to hold the inquiry, then once the commission comes to conclusion, there is a prima facie case is posted and notice is given to both the sides. The complainant and other persons can be represented by a counsel also, but many times, most of the time, the commissions don't entertain the advocates because it is a direct concern of the person's human right. We hear the person himself. If for any other reasons he is not able to, then he can engage a counsel also. They can bring their witnesses, produce relevant documents, and for this purpose, procedural purpose, the Human Rights Commission is empowered with the power of civil court. It can summon witnesses, it can summon documents from any person to satisfy itself as to the violation or otherwise of any act. Now, if there is a violation, what happens? The commission recommends to the state to take action. It is a recommendation to take action against the violator, and also it is empowered to award compensation to the victims. Now, this compensation is only an interim measure at the time. It is the discretion of the commission, and the victim can ask for enhancement in proper judicial forum. But because of this recommendation power given, and it is not an executive power, executory power given to the commission, many times the Human Rights Commission is called as tiger without tooth. It can recommend, the government may accept or may reject its recommendation. But it is not so. The Act itself provides that The complainant, of course, it is right to approach Supreme Court or High Court under Article 32 or 226. At the same time, even the Human Rights Commission itself can approach High Court and Supreme Court and Supreme Court to say that, look here, we have found violation of serious nature of human rights and government machinery is not taking any action. Supreme Court may give executory orders, which are the law of the land. Now, under the Act, it is not always necessary for the victim to give complaint. The commission itself, suo motu, or by itself, what is called as by itself, can take note of violation and take action. Like reading in newspaper, if the commission feels that there is a violation of human rights, it can by itself register a case and take action. One simple example I will give you, instance I will give you. When I took over charge in Maharashtra as a chairman, on the way to office, I was reading newspaper because the distance was very long for me to travel from my official residence to commission. And in the paper, I saw a small item called as, it was reported that a particular 2 apartments were given dirty, polluted water, drinking water. And in spite of the complaints of the residents, no action was taken. And there was a small photograph, colored photograph of a glass of water in which even worms were floating. On the way I was looking at this, I said there was no complaint till then. So I came to the office and I said I registered it as a suo motu complaint and issued notice to the Maharashtra Municipal Corporation. The power, as I said, though it is not executable and only recommendatory, see what happened. By evening, I started getting phone calls from individuals. They were the residents of the apartments, which was the grieving party victim. And they said, thank you, sir, for your notice. The moment your notice came, the corporation engineers came there, they carried out every repair work. And for the first time in 6 months, we are getting clean, drinkable water. See, this is what happens. The commission, if it takes suo motu actions, also can work towards betterment and protection of human rights in the society. Now, as I was saying, the different wings working, I mentioned there is an investigation wing. What is the purpose of this investigation wing? This is headed by a police officer not below the rank of DGP or IGP. And other subordinate officers are superintendent of police, then inspectors and constables also. And all are drawn from the Home Department on deputation. Now, as long as they are working in the commission as investigating wing, they are under the control of the chairman of the commission, and neither the Home Department nor the state can interfere in their investigation. The job of this investigation wing is normally, as goes in the courts also, when the complaint comes, we look into the records and hearing the parties, both the sides, we try to decide whether there is a violation or not. But many times, the commission feels that the allegations are very serious and requires investigation. It is here the investigation wing comes into picture. The commission directs the investigation wing to investigate and send a confidential report to the commission based on which, along with the other material, we can look into it. Now, again, to give an example of myself, I had received a complaint from a jail inmate, prisoner in the Nashik jail, central jail, that her husband was beaten black and blue, and he was not allowed to speak to anybody. But she learned about it, and she said, "Please help me." Now, there was a short time for me, for the commission, because if I issue notice, there is every possibility that relevant evidence may disappear, and we may not get correct picture as to what happened. Immediately in the evening, I directed my investigation officer, IGP was, that go to the Nashik jail, record the entire evidence, investigate and record the entire evidence, and come back, give me the report. Now, because of this investigation wings act, fast act, or of course, it is the commission's suo motu action, we could find that the prisoner was beaten by the jail authorities themselves, black and blue, and for different reasons. And that's how we took action against the jail authorities. We recommended to the government, and even government accepted it. Along with that, we paid compensation also. Now, this compensation, as I said earlier, is the entire jurisdiction and power of the commission. If there is a violation, commission can award compensation. And this compensation can be anything. There is no limit at all. In one of the cases, I have given compensation of rupees 50 lakhs for police negligence causing a person to become paraplegic because of the gunshot injury. Now, there is no limit at all. Of course, the government can challenge your recommendation or the compensation amount also in the proper court. That is normally, it is the High Court. So there is the commission, though without executable orders power, like courts, though called as a tiger without tooth, it is still powerful according to me, and it is the will and wish of the person sitting there who can do the wonders to help the citizens to get their human rights properly. Now, apart from this inquiry on the complaint of violation of human rights, there are other functions also given to the Human Rights Commission. That is, it can important is it will be looking into the violations of human rights by custodial homes. What I mean by custodial homes? Custodial homes are the places where persons are kept in custody. It need not be as a prisoner. It need not be as accused in police station. It can also be orphanages, beggars' homes, or women rescue homes, senior citizens' homes, hospitals, government hospitals also, where the person is in custody of somebody else, government machinery. The commission is empowered to regularly check these custodial homes as to whether there is violation of any human rights of the custodial persons. Most of the time we used to give surprise checks and look into the conditions of the prisoners. Now, another important role given is to inquire into custodial deaths. custodial deaths, again, deaths while a person is in custody, or the encounter, the so-called as encounter deaths. For this purpose, under the Act, it is mandatory for the government or the Home Department or the concerned jurisdictional police to intimate the Commission any custodial deaths within 48 hours. A duty is cast on the Commission to find out whether the death was due to natural causes or suspicious, like custodial torture, custodial murder, or even there is a possibility of suicide while in custody, in custodial homes. These are all things to be looked into by the Commission. Now, my experience shows, though whenever a prisoner dies in custody, especially in prisons, hue and cry is raised that it is a violation of human rights because it is a custodial death. It is not strictly custodial death. He may be suffering. My experience is around 90 to 95% these prisoners die in the custody, in the prisons, are suffering from some diseases also, tuberculosis, cancer, and then withdrawal of narcotic drugs, and many times suicide by dejection in the life, etc. Now, this is where the Commission has to look into in detail, conduct investigation, and found whether the custodial death is due to violation of human rights. Now, the next function entrusted to the Commission is to promote and bring awareness amongst various sections of the people, including the college students, law college, especially law college students, and hold seminars and lectures to enlighten the public about their human rights and remedies. Also, the Commission publishes books on different aspects of human rights also. Now, many NGOs, there are many NGOs across the state who approach the Commission, bringing it to its notice particular violations of. Now, at this stage itself, I would like to caution the members, the student community as well as the others, that though there are hundreds of NGOs in every state, be careful about their credibility. Be careful about their credibility. Because no doubt there are top-rated NGOs working in India for protection of human rights, like the Nobel laureate Kailash Satyarthi or the others. But there are fake NGOs who extract money from the victims or complainants in the name of getting them justice of violation of human rights. As the machinery I said, the Commission is cost effective. There is no fee, no payment of any sort of fees. These people, the fake NGOs, collect money in the name of Commission, and they make money, and they may not get, and they come to the Commission saying that we are the NGOs, and they get the relief freely. So we must be careful about these NGOs also. As I said again, there are top level NGOs working in India and everywhere, like Kailash Satyarthi, who is working for the protection of children. Then Amnesty International is there, Care India is there, Helpage India, Akshay Patra Foundation. All these are top level. We must be able to distinguish between good NGOs and bad NGOs. Now, this is in broad information about human rights and institutions and institutions under the Protection of Human Rights Act. Now, at this stage, I would like to say advantage of approaching Human Rights Commission. Now, any person need not be a victim. can approach these commissions, bringing it to its notice violation of human rights of any other person. This is the first, because in the court, you have the complainant must be the person who is a victim, if he is alive. That is not required here. Now, second, as I said, it is totally cost-free. At no point of time, any fees, unlike court fee or stamp duty, is required to be paid. Victim gets kept in loop all the while, and he gets all the reports or the document copies at every stage, again free of cost. Now it is hassle-free, as I said. No prescribed form is required to be prescribed for filing a complaint. No strict rules of Evidence Act, etc., are applicable. And there is no technical or legal issues involved, and subjective satisfaction is required. So there need not be even need of engaging a legal expert. The parties themselves can come and state their complaint. So these are all the advantages of the approaching a human rights commissions. Remember, government has no control or hold over the decision-making power of the commission because it is independent statutory body. The concern of government is only to provide the necessary budget, as also look into the recommendations, accept it or reject it for reasons to be given. That is required under the law, that they must inform why they are rejecting the recommendation made by the commission. Now, this is the greatest advantage is this is the quickest remedy, unlike court where it takes years and decades to decide a case. Now, of course, having seen this disadvantage, let me tell you some drawbacks in this machinery. The first drawback, what I felt, is absence of executing power of implementation of its order. This is the biggest disadvantage. As I said, it can make only recommendation, and no doubt, I mentioned it, that commission itself can go to the High Court or Supreme Court. But the financial constraints and budget of the commission, as in other institutions, also come in the way, and not every case where your recommendation is violated can be looked into. So this is one of this. This should, though it is a statutory body, it has got no power of passing executable orders. There are apathies, certain apathies in many states, as we have seen in the conferences, national conferences of human rights commissions. Many state governments are not so interested in maintaining these institutions. There is a total apathy. Many states have no chairman, no members appointed, and in fact, it was in Maharashtra. After I left, some NGO or some people had to file a writ petition in the High Court seeking direction to appoint commission, chairman and members of the commission. So this is sort of apathy on the part of, this is the one drawback. Though it is a universal problem concerning institution, it should be given proper attention by all the governments. Now, one more interesting aspect in this, which I found, is though the Act provides for human rights courts at every district, till today, nowhere in India there are district courts established. to look into human rights violation cases. Of course, our Kilpar director is there. I had discussion with him in this regard also. It is mandatory under the Act. What the governments everywhere have done is to designate a district judge as a human rights judge, human rights court judge. But there is no proper machinery established. There are many aspects, procedural aspects are there. Penal laws have to be made. Violation of human rights, what is the punishment? Whether it is fine only or imprisonment, etc. Not looked into. Jurisdiction question. All these, there must be a clear law. And then only the functioning of human rights courts would be proper. Merely designating a district judge by as a human rights court by a notification or order by the government is insufficient. This has to be looked into by everyone concerned. So ultimately, ladies and gentlemen, my say is this: though there is a machinery under the human rights commissions, both state and national levels, ultimately it is for the public or citizens themselves. They must have a mindset to protect human rights of another fellow citizens. When we demand our right, we conveniently forget our duties and obligations to the other fellow human being who has also got similar rights. We always forget that. Now, as I said, I was telling you earlier, people claim that I have no right to wear, I mean, you can't compel me to wear mask, for example. Now, fine, you have a right not to be compelled to be masked. What about the rights of others not to get the infection? Supposing you are an infected person, you are infecting, thereby creating a chain reaction, you are infecting hundreds of people. So this, we are forgetting whenever we claim human rights, we must keep in mind whether we are violating the human rights of others also. Others, individuals, as well as the entire society. This is what we are not keeping in mind when we claim ourselves either fundamental rights or human rights. Friends, this is no doubt, the mankind has achieved great unimaginable success. Unfortunately, the moral ethics and values are going down in the society day by day. Ronald Dworkin, an eminent jurist and philosopher, says, moral values are required to be protected and preserved for betterment of the society. We need a lot of changes, especially among my student friends who will be the next rulers and next generation for the society. They must look into this aspect. Nelson Mandela's quote, of course, a very universal quote, to deny people of their human rights is to challenge their very humanity. Mahatma Gandhi has also said, the greatness of humanity is not being human alone, but being humane. I remember here, and I will always quote this whenever talks of human rights come, a beautiful poem of Dr. Siddhaya Puranik, very, very commonly known poem. Everybody knows it, but nobody implements it. Odi Brahmana Nagu, Kadu Kshatriya Nagu, Shudra Vaishyani Nagu, Dudidu Galisi, ಏನಾದರೂ ಆಗು ನೀ ಬಯಸಿದಂತಾಗು ಏನಾದರೂ ಸರಿಯೇ ಮೊದಲು ಮಾನವನಾಗು Modalu Manavana. With this message of be humane to the human society, I once again thank the organizers, especially Dwarkanath Babu and Professor Ishwar Bhatt, for giving me a lot of time to address you all. Thank you very much. God bless you. Take care.
Thank you so much, sir.
Honorable Justice, sir, I am very grateful to you for having enlightened in the session and advised us regarding the role and development of human rights institutions and its drawbacks and other these things. I'm very thankful to you, sir, once again. Thank you, sir.
Thank you so much, sir. May I request Dr. Anup Prasannan, Assistant Professor, KSLU's Law School, to introduce the resource person for the second session, Professor Dr. P. Ishwar Bhatt, Honorable Vice Chancellor, Karnataka State Law University.
Thank you, Rashmi. Thank you, Rashmi. Yeah. It's a proud privilege for me to introduce Professor Dr. P. Ishwar Bhatt, the Vice Chancellor of Karnataka State Law University. Professor Ishwar Bhatt procured his PhD in law from the University of Mysore and LLD from National Law School of India University, Bangalore. Sir has an illustrious teaching experience of 40 years and has taught in different parts of Karnataka, Kolkata, and even abroad. Sir has also served as acting Vice Chancellor of the University of Mysore and Vice Chancellor of the West Bengal University of Juridical Studies. Sir's intellectual discourses in any branch of law is because of the proficiency in constitutional law and the subjects which he has taught, which includes administrative law, law and social transformation, non-profit voluntary organizations law, legal research methodology, intellectual property rights, and water law. Sir has more than 130 research articles to his credit, including a recent book on research methodology, idea and methods of legal research, and the recently edited book on law and social transformation. Sir's contribution in the field of legal knowledge has acclaimed him the honor of Professor Ubendra Bakshi National Award for Legal Research in 2020. With this brief introduction, I request our Honorable Vice Chancellor, Professor P. Ishwar Bhatt, sir, to address on the topic implementation of human rights and human rights codes. Over to you, sir, please.
Honorable Sri Dwarkanath Babu, Director of KILPAR, Karnataka Institute of Legal and Parliamentary Reforms, who is chairing the session. Honorable Sri J.C. Madhuswamy, who inaugurated this program. Honorable Justice S.R. Banurmat, who delivered an excellent, thought-provoking lecture on human rights and human right institutions. All the faculty members, participants, it gives me great pleasure in presenting my views on implementation of human rights and human rights codes. Please go to the next.
Yeah.
First of all, let me thank Sri Dwarkanath Babu for giving this wonderful opportunity of making a presentation. It's a very good venture that KILPAR has thought of discussing on human rights, because human rights is an evergreen and a very important subject. Coming to the rationale behind human rights, let me point out that the concern of various civilizations to recognize a human being as possessing the essential human worth ought to be a factor that's recognized in various circumstances, various instances, and through various legal norms and moral principles. Human rights, according to the Protection of Human Rights Act, means right to life, liberty, equality, fraternity, and dignity, and all human rights which are recognized and protected under human rights conventions and applied by the courts in India. There's it is providing for a very expansive definition. The essential purpose underlying a guarantee of human right is that the human worth and human dignity ought to be protected, and everyone is vested with all such endowments of developing his personality. Human rights are essential for a happy and harmonious life and also development. Happiness will be there if there are human rights. Harmony and brotherly relations will be there if there is a recognition of human rights. Or if a harmonious life is there, then there is a better recognition of human rights. Then development is possible through human rights. Development of human personality is possible through protection of human rights. Thus, human rights constitute central values for democracy, development, and the progress of the society as a whole. When we speak about human rights, we should also speak about the way in which those rights are protected. Guarantee of remedies is the method of protecting the rights. Rights and remedies go hand in hand. UB remedy. Wherever there is a right, there is a remedy. That is the basic principle of jurisprudence. Relating to human rights, it was recognized from the very inception of the mankind that it is through effective guarantee of remedies and effective implementation of rights that human rights get better protected. Insofar as Indian, there is ancient Indian ideas were concerned. Yes, it is through the process of performance of a duty that rights were recognized and they were protected. Insofar as the Anglo-Saxon system is concerned, we find that the whole of its invention, development, refinement, and creation of the whole body of a legal system was by emphasizing on the procedural aspects of rights. There is a procedural way in which human rights could be protected. There we find that the due process principle, or the idea that through effective remedies like writs, that rights shall be protected, or through various components of procedural rights, that rights shall be protected. It is through this court-driven system that rights got protected. Of course, Magna Carta and various other documents might have been created by the legislature, but we find that effective implementation of those principles was done by the judiciary, and the judiciary invented various writs, refined those writs, and it is said by Dicey that a writ of habeas corpus is just equivalent to a number of pages of constitutional guarantee of rights. Constitutional guarantee of rights does not become meaningful unless there is an effective remedial right, like a writ remedy. Through legislations like a writ of habeas corpus act, or through various other methods, the parliament recognized this procedural method through which rights could be protected. The efficacy of our rights much depends upon efficacy of our remedies. About that, there is no doubt. Historically, we find that procedural rights, principles of natural justice, and writ remedies became the strong pillars of human rights principles. See how through writ of habeas corpus, even right to equality and right against slavery could be protected. About that, we come across some examples. In England, when Lord Justice Mansfield delivered a judgment that the detention of slaves in a ship is going against the principle of dignity, and all the slaves who are detained in the ship shall be released immediately. He pointed out that through that creative right, or through that vibrant and most effective remedy of habeas corpus, so many rights could be protected in one stroke, in one single instance. See, slaves were brought from Africa to be transported to America, and they were anchored in the ship. And of course, when the learned judge considered that English air is too pure to be breathed by any slave, let the slave go free. Actually, that was the method through which equality, dignity, liberty, everything was protected through exercise of writ of habeas corpus. Thus, remedies are vital for a guarantee of rights. About that, there is no doubt. In the 20th century, there was much development about human rights. The idea of human rights grew amidst the experience of wars and atrocities. During wars, there was a brutal killing of thousands of persons. And in between wars, because of the genocidal activity, genocidal acts of Hitler and others had resulted in deaths of thousands of persons. In the light of this experience, it was considered that protection of human right through the national commitment and international commitment becomes very much important. Thus, a Universal Declaration of Human Rights was formulated on the basis of that experience, and there we come across a recognition of a number of human rights principles. Universal Declaration of Human Rights should be regarded as a seed bed of values, because so many rights sprouted, developed, and became very full-fledged principles in course of time. And the remedies that were made available for enforcement of those rights, these were left to the parties or to the concerned nations who were parties to this declaration. We come across a international convention on civil and political rights and various other conventions. There also much emphasis was given to the method of implementing the rights. It is not only mere recognition. Of course, a Universal Declaration was only a declaration, but the subsequent conventions were more serious efforts of not only guaranteeing rights, but also implementing those rights through specific methods. Today, I'm going to discuss about the trends of developments in all of this sphere. How there was that mixing of top-down and bottom-up approach or participative model in a protection of human rights. Implementation of human rights because of possible when the mechanisms, agencies, or institutions which are protecting those human rights interfere from the above, supervise, and provide certain remedies and make those rights enforceable through some positive means. There is a top-down model. On the other hand, there is a bottom-up approach or a participative model. See, on the basis of the human rights movement, which is expressed in the form of NGO movement or various other methods, the people participate, people demand those rights, and people persuade that the human rights institutions, maybe human rights commissions or human rights courts or various other bodies. There is ordinary courts, constitutional courts, and even the international bodies like a Human Rights Commission or the present Human Rights Council or Human Rights Committees constituted under various conventions. These participate and provide effective remedies. Thus, today's discussion will be pointing out about the trends of development in the whole of this sphere. I'll come to those aspects. Please go to the next slide. Related to implementation of human rights at the international level. Of course, I am planning my discussion in this way. Implementation of human rights takes place at the international level. Then implementation of human rights takes place through the exercise of power by the constitutional courts. There is a Supreme Court and High Courts. And implementation also takes place through the institutions like human rights commissions. Then we come across implementation of human rights through human rights courts at the district level. First, let me explain about the implementation of human rights at the international level. Here we come across two types of mechanisms. One is a convention-specific mechanism, and the other is a non-convention mechanism. Convention-specific mechanisms can be found in those. For example, International Convention on Economic, Social, and Cultural Rights. The first part 1 and 2, they elaborately provide for various rights, social, economic, social, and cultural rights. Then, in another part, we come across the formation of economic and social council's role. Article 16 to Article 23 provide for a formation of a human rights committee and a role of economic and social council. There is a compulsion upon the state parties to report to the Secretary General of the United Nations about the extent of a guarantee of human rights in their state. To what extent they have complied with the human rights conventions, whether they have ratified those conventions, whether they have enacted laws for implementation of those conventions. Are there any violation of human rights? About all those things, annually they have to submit reports to Secretary General of United Nations, and a copy shall also be sent to Economic and Social Council. And there is also transmission of such copies to the Commission on Human Rights. Then in turn, the whole matter will be brought before the General Assembly for discussion, and General Assembly discusses all those matters. Then subsidiary organs also discuss about the extent at which various nations have complied with the human rights principles. That's at the international level, relating to International Convention on Economic, Social, and Cultural Rights. To what extent those principles are complied? About that, we come across one mechanism. This is one method of creating public opinion, creating some forum for supervising and insisting that human rights principles under this convention shall be applied, shall be complied by all the member nations. Similarly, under International Convention on Civil and Political Rights, we come across a formation of one committee. There is a Human Rights Committee. It's an 18-member committee constituted on the basis of election, and all the nations of United Nations shall submit their reports to Secretary General of United Nations, and they shall submit a report to this Human Rights Committee about the extent of compliance with the International Covenant on Civil and Political Rights. There is a formation of a Conciliation Commission. See, Conciliation Commission has the role of ensuring that in case there is a violation of human right, such a violation will be remedied at the level of the concerned state. Now, suppose some other nation raises objection about a human right violation in another nation, that the people belonging to its nationality are victims of human rights violation in the concerned country, then those matters will be taken into consideration by this Conciliation Commission, and remedies will be there. In another convention, there is a convention on eradication of discrimination against racial discrimination. There's a convention on eradication of racial discrimination. There a committee is constituted under Article 8. This committee looks into various issues relating to violation of human rights. Here also, it is an obligation on the part of all the member nations to report to this committee about the extent of compliance with this Convention on Eradication of Discrimination against discrimination. There's a racial discrimination. Then Convention on Eradication of Discrimination against Women. There also we come across a formation of one committee on eradication of discrimination against women. This is an elected body, and this also performs the function of taking into consideration all the complaints that are lodged by various nations relating to the extent of compliance with this convention or extent of a violation of human rights. And this committee has also that power of supervision, power of giving suggestions, or power of giving directions to the concerned states about the extent, about the way in which these rights shall be complied. Then we come across a convention on rights of children. Under Article 43 of this convention, there is a formation of a committee on child rights. This committee consists of elected members, 10 experts, and various officers. And of course, this is a special committee which gives a number of suggestions about the way in which better protection of children could be made. It also gathers information from the member nations about the violation of child rights or complaints that are filed by various victims or NGOs or other persons about non-compliance with the Child Rights Convention. And this committee also performs those functions of supervision, giving direction, counseling, etc. Then we come across non-convention mechanisms. under UN Charter itself, there is a provision about the responsibility on the part of United Nations to ensure that there will be protection of human rights, because peace can be ensured only with the protection of human rights. That is the firmest belief of United Nations. And we come across a formation of a Human Rights Commission as a method through which human rights can be protected. Of course, this is not based upon any specific convention, but based on a resolution passed by the General Assembly that a Human Rights Commission was constituted. Until 2006, this Human Rights Commission was performing functions, but because of the careless approach on the part of Human Rights Commission, or a partisan approach, or the approach which was not very reasonable or fair, the nations had total distrust about this Human Rights Commission, because it was a partisan in its approach. It was favoring only some of the developed countries, and relating to the least developed countries or developing countries. It had a very prejudicial approach, and those prejudices were open when against Kashmir or various other positions. Some remarks were made, or certain comments were made by those bodies in a very unpalatable manner. In 2006, when the role of United States was recognized as not a dominant one, Human Rights Council was constituted. Of course, United States was a big brother insofar as the human rights guarantee is concerned. But at some point, there was a departure from its position, and post 2006, we come across a Human Rights Council 2006, and this Human Rights Council has rendered a great service to the cause of human rights. In the 21st century, in realizing the Millennium goals, it has contributed very significantly, and it has evolved a number of means through which better protection of human rights could be conducted. It is not only just gathering report, by persuading, by training, by sending its persons to various nations. The Human Rights Council is performing marvelous functions. Thus, at the international level, we come across some positive development, and here also the trend is towards involvement of the people, because just on the basis of power holders approach, it is not possible to protect the rights. It is from the side of the people's participation, or it is from the angle of performance of duties that we should look into the whole issue. Thus, a participative model can be found here. Yes, the top-down model is also not totally rejected, because these committees are in a position to supervise, persuade, warn, and inspire all these nations to comply with these human rights conventions. Please go to the next. Now, coming to the role of constitutional courts in India, let me point out that human rights in India have become quite stable and quite vibrant, and also developing with expansionist approach, both about the content of rights, scope of rights, or about its application. We come across a big change, revolutionary change. And for all such changes, Supreme Court's interpretation of Part 3 of the Constitution was responsible. High Court's interpretation was also responsible. Insofar as Part 3 is concerned, by expanding each and every provision of Part 3 of the Constitution, the court has enlarged the scope of rights. And human rights have become excellently protected because of such an approach. High courts have also expanded the scope of rights. We find that various rights, especially right to life, have been interpreted in a very expansive manner. Right to life includes almost all the important aspects of human dignity, all positive rights, not mere continuation of human life, but living with the human dignity, to have all such positive rights like food, shelter, or say education, livelihood, health, environment, and so many of positive rights are incorporated, or they're recognized as a part and parcel of a right to life. About equality, we come across a expansionist approach again through interpretation. About the policy of reservation, or about the new facets of rights. There's a reasonableness or proportionality, and various other new principles, new facets have emerged. Insofar as liberty is concerned, again, expansion of each and every liberty can be found. Then relating to right to education, or right against exploitation, relating to each and every right, we come across such a expansionist approach, and a marvelous achievement is done by the constitutional courts in expanding the scope of rights. Part 4 of the Constitution is also absorbed, or it is used in the course of interpretation. For all these things, it is the application of Article 32 and 226 of the Constitution. Again, implementation of rights that has added worth to the human rights principles. There we come across a role of Article 32. A revolutionary development has taken place in the field of writ law. There's through public recognition of public interest litigation. Yes, by liberalizing locus standi, by providing that there need not be exhaustion of alternative remedies, or by saying that delay is not a factor that will come in the way of getting the right. By providing for so many such inventions in the field of writs, there is an expansion of the scope of human rights. And most important development is public interest litigation. It is actually recognition of the participative role of the people. So many NGOs, so many social activists, and so many public spirited entities are participating in getting remedies. It is not necessary that the aggrieved person himself or herself should come to the court and knock the doors of justice. On behalf of the vulnerable sections, on behalf of the persons who are not able to go to court of law, suppose the social activists or NGOs can move the court. That is also something permissible. Public interest litigation has experimented in a legal aid, application of various other procedural methods. There's by not insisting on a formal submission of petitions, by allowing petitions through postal communication also, it is possible to get a remedy. So many inventions and innovations have taken place. And National Human Rights Commission and State Human Rights Commission constituted under Protection of Human Rights Act of 1993 also assist the Supreme Court and High Courts. So many cases, NHRC is a party, or NHRC is investigating, or the court is entrusting the responsibility of investigation or supervision by NHRC. There is that kind of a link between a Supreme Court and NHRC, or Supreme Court and a State Human Rights Commission, or High Court and a State Human Rights Commission. Then we come across tribunals. Tribunals also contribute to the cause of human rights. Now, when the Interstate Water Dispute Tribunal decides about the apportionment of water and entitlement of various states relating to water, then it has some human right element, because when right to water has a human right component, then recognition of that right to water has also human right principle, and tribunal also performs such a function. We come across another set of constitutional courts which are not yet brought into existence. There is Article 32, Clause 3 of the Constitution. I would like to draw the attention of the participants to this particular provision, which is not put into effect. Article 32, Clause 3 says, without prejudice to the powers conferred on the Supreme Court by Clause 1 and 2, Parliament may, by law, empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under Clause 2. See, this is a very crucial provision which can operate as a boon to the whole domain of human rights principles. Honorable Justice, Chief Justice E.S. Venkatramaya, in one of his writings and also in his speech, has emphasized about the need to activate this particular clause. His suggestion is that if the district judge in all the districts is entrusted with at least the power of a court to issue writ of habeas corpus, then it will solve a number of issues, and it will provide remedy at the district level. The individuals need not go to the seat of High Court. At the district level itself, it is possible to get such a remedy. Now, suppose there is a kidnapping of a child, or there is a police atrocity, or there is a say unreasonable detention by the police, and there is a need to invoke the jurisdiction of a writ court. Going to High Court may be disadvantageous to the victim or to the aggrieved person, and approaching the district judge may be quite appropriate. See, simple legislation from the side of a parliament will be sufficient to confer that right or that power on the part of the district judge to provide such a remedy. Of course, first there can be experimentation with the writ of habeas corpus. Suppose that is successful, other writs can be subsequently introduced. Yes. We find that constitutional courts have played a very important role. Now coming to the next one. Yes, please. Human Rights Courts. Protection of Human Rights Act 1993 has a number of salutary provisions relating to protection of human rights. In the preamble itself, there is a mention of the purpose for which this legislation is enacted. There is a formation of National Human Rights Commission, State Human Rights Commission, and creation of a human rights court is the purpose of this legislation. In the preamble itself, that's clear. But unfortunately, about the role of a human rights court, adequate attention was not given. There is a provision under Section 30 providing that yes, there is a jurisdiction on the part of a human rights court to promote the cause of a speedy trial, etc. Let me read that particular clause. For the purpose of providing for a speedy trial of offences arising out of a violation of human rights, the state government may, with the concurrence of chief judges of the High Court, by notification specify for each district court, for each district, a court of a session to be human rights court to try the said offences. Here, the words arising out of a violation of human right. There is a, for dealing with the offences arising out of violation of human rights. See, this particular phrase is not properly defined, or there is no interpretation about that. Anything can be brought under the purview of this particular phrase, arising out of violation of human rights. First, there should be offense, and that offense should be something arising out of violation of human rights. Whether it is necessary that a violation of human rights should occur because of the act of the public official, like a police officer or some other officer of the government or public servant, or whether it can be even a violation of human right by any private individual also. See, under Indian Penal Code, we come across a number of offences related to human body. These are actually violations of human rights: right to life, right to dignity, right to freedom of movement, or right against defamation, then a right to reputation, then a right to privacy, physical autonomy, right not to be subjected to any kind of offences. All these are human rights. And if any private individual resorts to any of such acts, then also there is violation of human right. But whether that is also contemplated under this, it's difficult to say so, or even to exclude, because the provision does not provide for confining this clause only to acts performed by the public servants. But for the sake of convenience, or for the sake of administration of the law in an effective manner, yes, invoking the provisions of Indian Penal Code, Criminal Procedure Code, or various other laws, maybe providing remedies to the concerned individual. And this is a special legislation. Of course, if there is an act of untouchability, that act of untouchability is an offense under a legislation, and it is a constitutionally recognized violation of human right, because it necessarily results in a violation of Article 17 of the Constitution. In such circumstance, to what extent jurisdiction can be conferred upon such bodies? About all those things, there were certain doubts or uncertainties, and of course, Section 30 of Protection of Human Rights Act became a silent provision. It did not come into effect because of a lack of notification about the way in which such a provision could be put into effect. The provision to section 30 says, provided that nothing in this section shall apply if a court of a session is already specified as a special court, or a special court is already constituted for such offences under any other law for the time in force. Under so many legislations, we come across a recognition of the jurisdiction of a district court as the competent court for taking actions against some of the offences, like say atrocities against the scheduled caste and scheduled tribes, or say offences under Immoral Traffic Prevention Act, or offense under such a type of legislation. There, the concerned offense is under the, it is triable by the assigned or the designated court. See, one problem that arose because of failure to formulate rules was that so many courts were entrusted with the responsibility of implementing those specific laws or those special laws, like Atrocities Act, or Immoral Traffic Prevention Act, or so many such legislations which are protecting human rights. But whether the magistrate has whether the magistrate under whose jurisdiction the offense has taken place refers the matter, or he commutes the matter to the district court, that becomes so crucial. Suppose under section 133 of the act, he has not done that, then the invocation of the jurisdiction of the concerned court will not be possible. Then another problem also was faced by the courts when any public servant has committed any wrong. There is has committed any offense arising out of a violation of human right. For example, there is a police brutality, or torturing, or a third-degree method, either in a prison or in lockup, or soon after arrest, or in the process of encounter or such a thing. Then it is really an offense arising out of violation of human right. About that, there is no doubt. But in the absence of any rule providing for a recognition of the jurisdiction of the court, whether the concerned court can exercise a jurisdiction, about this there was such a problem. And it is only in 2006 Karnataka government enacted rules, and those rules provide for such a recognition. Of course, insofar as section 30 is concerned, there are other supporting measures like public prosecutor's role. Any advocate who has experience of more than 7 years as an advocate may be designated as a special public prosecutor for that purpose. About the role of this human rights courts after 2006, we have to discuss. Yes, please go to the next slide. Karnataka State Human Rights Courts rules enacted in 2006 recognizes the jurisdiction of the courts. There's a district courts for exercising a jurisdiction. All offences of violation of human rights shall be tried by the court. Then Rule 4, the court, while trying an offence of a violation of human rights, may charge and try the accused for any other offence which may have been committed by the accused in the course of the same transaction in one trial for every such offence. That's a joinder of a charge is also possible. Then relating to jurisdiction, Rule 5 points out, any offence of violation of human right shall ordinarily be tried by the court within whose local jurisdiction it was committed. Please go to the next slide. Here we come across the procedure that is adopted for a human rights court. Victim of an offence arising out of a violation of human rights, his legal representative or a registered NGOs or public person may file a complaint against a public servant who has committed or abetted the commission of an offence of violation of human right while acting under the color of his office as a public servant. See, here, who can file a complaint against a violation of human right? About this, this clause gives answer. A victim of an offence can file a complaint. His legal representative can file a complaint, or a registered NGO can file a complaint, or even a public person may also file a complaint. See, complaint against whom? Complaint not against a private individual. Complaint against a public servant who has committed or abetted the commission of an offence. That's the offence of a violation of human right. See, their complaint can be filed. Just a few minutes earlier, I pointed out the possible interpretation of that section 30, which can include even a private violation of human right also. But here, this rule recognizes the jurisdiction only insofar as complaints against public servants are concerned. See, the violation of human rights by public servants, either through their positive or covert act or through their omissions, are serious matters. In a DK Basu case or in various cases, whether it's a Sebastian Hongre case or Nilavati Behra case or a number of cases, we come across police atrocities, third-degree methods, and such things, which have put the victims into a very, very vulnerable position. Now, this particular rule tries to provide safeguard by conferring a jurisdiction to the district court. Then, in such a situations where an NGO or a public person is a complainant, prior authorization by the victim is essential, or affidavit in support of that authorization is also essential. In such circumstance only that NGOs can file. Thus, NGOs cannot misuse their position. Honorable Justice Banur Mat sir had said about the possibility of good NGOs, bad NGOs, and such things. It is quite possible that NGOs may file false complaints, or they may resort to say blackmailing or such things. In order to avoid all those things, it is essential that there shall be this kind of a safeguard. Then the court, on receipt of such a complaint, shall either order an investigation into the offense by a police officer not below the rank of a superintendent of police, or it may proceed to conduct its own inquiry into the complaint in accordance with the procedure for dealing with the private complaints in the court. Yes, here, police officers not below the rank of a superintendent of police should be entrusted with the responsibility of an investigation. Yes, there is no problem about that. Very responsible officer is designated here. What about proceeding to conduct its own inquiry? See, judiciary exercising the power of investigation or inquiry is something unusual. But here, when it is done by the judiciary with the purpose of better protection of the human rights, it is permissible, because that power is exercised by an adjudicating body, and the purpose is to protect the rights of people. And how exactly private complaints are dealt in the same way that it is to be dealt. Yes, please go to the lower one. Yes, superintendent of he shall complete such an investigation well in time. Then a day-to-day basis. I mean, on day-to-day basis, that all such trials should take place. Yes, please. I'm not in a position to. Yes, such a trial shall have precedence. Yes, special procedure for a speedy trial. The trial, once commenced, shall be held on a day-to-day basis, provided it may be adjourned for more than one day, only for special reasons to be recorded in writing. Thus, the general principle is that on day-to-day basis that it shall take place. Thus, of course, the fast track court type of thing is contemplated here. Then such a trial shall have precedence over any other trial pending against the same accused person or an accused person in another court. Yes, so please go to the next. Some of the examples can be found. Professor Chidambar Reddy in his article has cited and elaborately discussed about this case. There is a N. Ramachandran versus H. Makandar. This was a judgment given by Principal Sessions Judge, Human Rights Court, Bijapur. Judge Shri S.M. Patil had delivered that judgment. It involved a very shocking state of affairs, where a railway officer, an engineer, was arrested, and he was handcuffed. He was beaten badly, and of course he was paraded in front of the public. The charge was about theft of certain materials. Of course, for violation of all such norms which were laid down in various earlier cases, a D.K. Basu case, or this earlier case relating to handcuff, etc. Of course, those cases were cited, and the court awarded a compensation against the officers who were responsible. Then we come across other cases. Keta Venkataswamy versus Bhaskar Rao, a judgment given by Andhra Pradesh High Court. There also, the court awarded compensation against police atrocities resulting in the death of a person. Yes, there are, although the compensation that was awarded by the single judge bench was reduced by the divisional bench, at least there was a recognition of this court's responsibility See whether human rights courts can award compensation, or what powers are there on the part of human rights courts about all those principles, about all those things. Principles are not well settled, but they have discretionary power under provisions relating to victim compensation. They have such a powers. Then we come across other cases also where similar approach was adopted and compensation was awarded. But when there was a false complaint or not every tenable complaint by an individual against a police officer, that police officer visited that place in connection with the civil suit, and he had acted in an unreasonable manner, favoring one of the parties, and there was violation of human rights, etc. There, filing such a complaint was without taking prior sanction of the higher authority. Under Section 197 of our Criminal Procedure Code, there is a requirement that before prosecuting any public servant, there is a need to get the prior approval or a sanction for a prosecution from the higher authority or a superior authority under whose disciplinary jurisdiction that person comes. But when there was a non-compliance with that provision, of course, the Human Rights Court cannot exercise its jurisdiction. That was one judgment rendered in one of the cases. These are some of the examples, but these examples are very sparse examples. See, Human Rights Court's jurisprudence is not well developed. What are their powers? What are their responsibilities? How they can deal, and in how many cases they have provided remedies concerning all these things? The law is not well developed, and it is essential that there ought to be such a development. Yes, coming to our conclusion part. Yes, next slide. The trend of development in all these spheres, whether at international level or national level, state level or district level, there we come across a combining of this top-down model with a bottom-up approach. There's a tilt in favor of a bottom-up approach, but there is no abandonment of a top-down model. Then from an adversarial system to non-adversarial system, there is a shift. Then about the types of remedies, we come across the expansion of remedies like anything. See, during the pandemics, we come across wonderful judgments by the Supreme Court and High Courts, providing for a number of remedies, whether relating to under trial prisons or the hospitals or children or people in protective homes or various other entities. See, concerning so many aspects about the type of treatment or about the treatment of dead bodies or so many other things, we come across very important judgments that shows the vibrant judicial system we have. Then we come across expansion of various agencies for protection of human rights. There is a diversity. Tribunals are there, human rights commissions are there, then courts are there, and so many other bodies. Then we come across a creative role of NGOs. NGOs at the international level, at the state level, play very, very prominent role, whether it's Amnesty International or say this Red Cross or various other bodies, or at the state level, local level. All these NGOs play a very important role, and successful implementation of human rights ideas much depend upon the concerted actions on the part of a number of bodies, including NGOs. Then legal aid and PL movement has promoted equal justice for all. There is a need for expanding the scope of human rights courts to cover non-state entities. But we have to think about the modalities and the limits within which it could be done. At least insofar as the public servants are concerned, invocation of the jurisdiction of human rights courts becomes very much essential. These are some of the thoughts that I'm sharing with you. I'm very much grateful to Sri Dwarkanath Babu, very eminent, knowledgeable person in the field of law, legislative drafting, and various other areas. It is a marvelous knowledge we have to admire about Sri Dwarkanath Babu. I'm quite confident that yes, our association with the Kilpar is quite fruitful, and in future also we look for such events, such a participation, so that in a concerted manner, so many good things can be done from the side of law department. So thank you very much, sir.
Sir, thank you, sir, Professor Ishwar Bhatt, sir, Honorable Vice Chancellor. You have enlightened regarding the remedies and the process of implementation of human rights. You have also enlightened regarding the international level remedies, conventional method and other methods, non-conventional method, and at the national level and at the state level. You have also pointed out the role of human rights courts at district level, and no doubt, as you suggested, it requires further development in the modalities that courts have to be adopted at district level. Thank you, sir.
Thank you.
I thank you once again for this lecture.
Thank you so much, sir. I now request Dr. Rajendra Kumar Hittangi, Assistant Professor, KSLU, to kindly introduce the President for the webinar, Shri K. Dwarkanath Babu, Director, Karnataka Institute for Law and Parliamentary Reforms. Please, sir.
Good afternoon to all. I'm happy to introduce the President of today's program and the Director of Kilpar, Bangalore. Sir graduated in Commerce in the year 1978 from Bangalore University. Sir also obtained law degree and PG degree from Bangalore University. Sir joined government service in 1983, and Sir was a Special Secretary to Government of Karnataka, Department of Parliamentary Affairs and Legislation, and also a Secretary to the Government of Karnataka, Parliamentary Affairs and Legislation since 2016 to 2021. Sir was also a member of a syndicate and the Academic Council of Karnataka State Law University in Hubballi. Sir is also a member of the Karnataka Institute for Law and Parliamentary Reforms, and Sir has worked more than 10 years as a secretary in the scrutinizing committee under the chairmanship of Honorable Law Minister. And Sir has worked as an advisor to the Committee on Subordinate Legislation of State Legislature for more than 10 years. And Sir was instrumental in drafting major legislations. Sir, we are really happy to have you in this particular program. Over to you, sir, for the presidential remarks. Thank you, sir.
Good afternoon. It's a pleasure to have this kind of orientation and enlightening session, and I am thankful to Honorable Justice, Honorable Minister for Law for inaugurating this session, and Honorable Justice Banurmat sir has also explained the role of Human Rights Commission and other things. This institution was established in 2005 by the state government as an attempt towards bringing awareness among the citizens and student faculties and other communities. This institution not only plans for awareness programs, but also take up research work and would like to send recommendations to the state government in the gray areas where law has to be modified, reformed, or to be developed. During this day's session, we are happy. We have received many information regarding the human rights, how they have took its origin, how they are developed, and how they are being implemented at national level, state level, and district levels. It's a very good enlightening for student faculties and other dignitaries. See, here we have received many information regarding the modifications or developments that are still required to be. See, as law is not a stagnant subject, it is a dynamic subject. It requires reformation at every stage. And unless we improve and develop good modalities in the delivery of justice or other things, law cannot reach common man. To reach common man, there should be a dynamic development of law. This kind of storming sessions will bring us more information regarding the improvements that has to be made in the laws that are prevalent at present. Further, I would like to quote that even in spite of several universal declarations, we are not able to achieve proper human rights at international level, at national level, or at district level. Recently, as everybody has noticed, in Afghanistan, when there was a turmoil, many peoples were killed, and there was no law prevalent. There was huge violation of human rights, and no United Nations organization or any organization came to the rescue of innocent people. See, in our nation, 1993 Human Rights Act was enacted. Earlier to that, in Kashmir, when Pandits from Kashmir were sent out brutally and were killed, and their properties have been taken away. See, in United Nations declaration, right to property is also one of the human rights. Whereas when we look at our constitution, right to property has been removed from the part 3 of the constitution. It has shifted to article 300A. It is no more a fundamental right, but it should be protected. See, when properties of the Kashmir people were taken away and they were sent out of their homeland, they became homeless. This kind of violation of human rights after 40 years, 50 years of independence has taken place. This has to be curbed, and you are facing similar several problems of violation of human rights. Unless awareness is brought among the citizens, and as legal students, you must have good awareness regarding the human rights, and you are the citizens tomorrow who will be in administration and to separate the violations as a legal practitioners. I hope this session has brought very good result, and I conclude here with this notes. Thanking you.
Thank you so much, sir. May I request Dr. Revaya Odayer, Research Head, Karnataka Institute for Law and Parliamentary Reforms, to kindly propose the vote of thanks. Please, sir.
Hello, Odayer sir. You are not audible. No.
ನಮಸ್ಕಾರ. ಕ್ಷಮೆ ಇರಲಿ. ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ಹಾಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯ ಈ ಎರಡು ಸಂಸ್ಥೆಗಳ ಸಹಯೋಗದೊಂದಿಗೆ ನಡೆದ ಮಾನವ ಹಕ್ಕುಗಳು ರಾಷ್ಟ್ರೀಯ ವೆಬಿನಾರ್ ನನ್ನ ಉದ್ಘಾಟನೆ ಮಾಡಿರ್ತಕ್ಕಂತಹ ಸನ್ಮಾನ್ಯ ಕಾನೂನು ಸಚಿವರಾಗಿರ್ತಕ್ಕಂಥ ಮಾನ್ಯ ಜೆ.ಸಿ. ಮಾಧುಸ್ವಾಮಿ ಸಾಹೇಬರಿಗೆ ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ಹಾಗೂ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಕೃತಜ್ಞತೆ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಈ ಕಾರ್ಯಕ್ರಮವನ್ನ ಅತ್ಯುತ್ತಮವಾಗಿ ಮೊದಲ ಗೋಷ್ಠಿಯಲ್ಲಿ ಮಾತಾಡ್ತಕ್ಕಂತಹ ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾಗಿರ್ತಕ್ಕಂತಹ ಜಸ್ಟಿಸ್ S.R. ಬಂದೂರ್ಮಠ್ ಸಾಹೇಬರು, ಕಾನೂನು ಆಯೋಗದ ಅಧ್ಯಕ್ಷರು, ಅವರಿಗೂ ಸಹ ಈ ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಕೃತಜ್ಞತೆಗಳನ್ನ ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇವೆ. ಇನ್ನು ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ಎಲ್ಲ ಕಾರ್ಯಕ್ರಮಗಳಿಗೆ ಸದಾ ಬೆನ್ನೆಲುಬಾಗಿ ಎಲ್ಲ ಕಾರ್ಯಕ್ರಮಗಳಿಗೆ ಒಂದು ವಿದ್ವತ್ತಿನ ಪ್ರೌಢಮೆಯನ್ನು ಒದಗಿಸ್ತಕ್ಕಂತಹ ನಮ್ಮ ಕುಲಪತಿಗಳು ಡಾಕ್ಟರ್ ಪಿ. ಈಶ್ವರ್ ಭಟ್ ಸಾಹೇಬರಿಗೆ ಈ ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ಮತ್ತು ಎಲ್ಲ ಕೇಳುಗರ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಅಧ್ಯಕ್ಷತೆಯನ್ನು ವಹಿಸಿ ಅಧ್ಯಕ್ಷೀಯ ಭಾಷಣ ಮಾಡತಕ್ಕಂತಹ ನಮ್ಮ ಹಿರಿಯರು ಮತ್ತು ಕಾನೂನು ಸಂಸದೀಯ ವ್ಯವಹಾರಗಳ ಇಲಾಖೆಯ ಕಾರ್ಯದರ್ಶಿಗಳಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿ ಈಗ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕರಾಗಿ ಪಣ ಮತ್ತು ಅತ್ಯುತ್ತಮ ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ನಮಗೆ ನೀಡಿರ್ತಕ್ಕಂತಹ ಶ್ರೀ ಕೆ. ದ್ವಾರಕಾಂತ್ ಬಾಬು ಸಾಹೇಬ್ರವರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ವೈಯಕ್ತಿಕವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಉಪಸ್ಥಿತರಿದ್ದು ನಮ್ಮ ಎಲ್ಲ ಕಾರ್ಯಕ್ರಮವನ್ನು ಆಲಿಸತಕ್ಕಂತಹ ಜಸ್ಟಿಸ್ P.S. ನಾರಾಯಣ್ ಸಾಹೇಬರಿಗೆ ನಾವು ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ಧನ್ಯವಾದಗಳನ್ನು ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇನೆ. ಅದೇ ರೀತಿ ಕರ್ನಾಟಕ ಕಾನೂನು ಆಯೋಗದ ಸದಸ್ಯರಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸತಕ್ಕಂತಹ ಜಸ್ಟಿಸ್ ಅಶೋಕ್ ಜಿ. ನಿಜಗಣ್ಣ ಸಾಹೇಬರು ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಉಪಸ್ಥಿತರಿದ್ದು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಆಲಿಸಿದ್ದಾರೆ. ಅವರಿಗೂ ಸಹ ನಾವು ಈ ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇನೆ. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ 500ಕ್ಕಿಂತ ಹೆಚ್ಚು ಜನರು ಭಾಗವಹಿಸಿದ್ದಾರೆ ಮತ್ತು 12 ರಾಜ್ಯಗಳ ವಿವಿಧ ರಾಜ್ಯಗಳಿಂದ ರಿಜಿಸ್ಟರ್ ಆಗಿ ಅವರು ಕೂಡ ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಈ ಕಾರ್ಯಕ್ರಮದ ಮಹತ್ವವನ್ನ ಅರಿತು ಒಂದು ಮಾಹಿತಿಯನ್ನು ಪಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅವರೆಲ್ಲರಿಗೂ ನಾವು ಈ ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಕಾರ್ಯಕ್ರಮವನ್ನ ಆಯೋಜನೆ ಮಾಡಲಿಕ್ಕೆ ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಪ್ರೊಫೆಸರ್ ಆಗಿರ್ತಕ್ಕಂಥ ಡಾಕ್ಟರ್ C.S. ಪಾಟೀಲ್ ಸಾಹೇಬರಿಗೆ, ಕರ್ನಾಟಕ ವಿಶ್ವವಿದ್ಯಾಲಯದ ರಿಜಿಸ್ಟರ್ ಆಗಿರ್ತಕ್ಕಂಥ ಮೌಲ್ಯಮಾಪನ ವಿಭಾಗದ ರಿಜಿಸ್ಟರ್ ಆಗಿರ್ತಕ್ಕಂಥ ಪ್ರೊಫೆಸರ್ G.B. ಪಾಟೀಲ್ ಸಾಹೇಬ್ರವರಿಗೆ, ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ರಿಜಿಸ್ಟ್ರಾರ್, ಆಡಳಿತ ವಿಭಾಗದ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಗಿರ್ತಕ್ಕಂಥ ಪ್ರೊಫೆಸರ್ ರತ್ನ ಭರಮನಗೌಡ ಅವರಿಗೆ ಮತ್ತು ಮೊಹಮ್ಮದ್ ಜುಬೇರ್ ಅವರಿಗೂ ಸಹ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ನಮ್ಮ ಈ ಕಾರ್ಯಾಗಾರವನ್ನು, ಈ ವೆಬಿನಾರ್ ಅನ್ನು ಅಚ್ಚುಕಟ್ಟಾಗಿ ನಿರ್ವಹಣೆ ಮಾಡಲಿಕ್ಕೆ ಮತ್ತು ಆರಂಭದಿಂದ ನಮ್ಮ ಜೊತೆಗೆ ಹೆಗಲ್ಪಟ್ಟಿರ್ತಕ್ಕಂಥವ್ರು ಅಂದ್ರೆ ಡಾಕ್ಟರ್ ರಂಗಸ್ವಾಮಿ ಅವರು ಆರೋಗ್ಯದ ಕಾರಣಕ್ಕಾಗಿ 2-3 ದಿನ ನಮ್ಮಿಂದ ದೂರ ಇದ್ರೂ ಸಹ ಪ್ರತಿ ಹಂತದಲ್ಲೂ ನಮ್ಮ ವಿಚಾರಗಳನ್ನ ಮತ್ತು ನಮ್ಮ ಆಗುಗಳನ್ನ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರಿಗೂ ಕೂಡ ನಾವು ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಇನ್ನು ಡಾಕ್ಟರ್ ರಾಜೇಂದ್ರ ಹಿಟ್ಟಣಿಗೆ ಇವರು ಸಹ ಅತ್ಯುತ್ತಮವಾಗಿ ನಮ್ಮ ಜೊತೆಗೆ ಕಾರ್ಯನಿರ್ವಹಣೆಗೆ ಕೈ ಜೋಡಿಸಿರ್ತಾರೆ. ಇವರಿಗೆ ನಾವು ಸಂಸ್ಥೆಯ ವತಿಯಿಂದ, ವಿಶ್ವವಿದ್ಯಾಲಯದ ವತಿಯಿಂದ ಮತ್ತು ಎಲ್ಲ ಕೇಳುಗರ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಈ ಕಾರ್ಯಾಗಾರದಲ್ಲಿ ಎಲ್ಲ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಕಾನೂನು ಕಾಲೇಜುಗಳ ಪ್ರಿನ್ಸಿಪಾಲ್ಗಳು ಮತ್ತು ವಿದ್ಯಾರ್ಥಿನಿಯರು ಮತ್ತು ಅಧ್ಯಾಪಕ ವರ್ಗದವರು ಜೊತೆಗೂಡಿ ಎಲ್ಲವನ್ನು ಆಲಿಸಿರ್ತಾರೆ. ಅವರಿಗೂ ಕೂಡ ನಾವು ನಮ್ಮ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಇಷ್ಟೊತ್ತು ಆಲಿಸಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ಕೇಳುಗರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದ ಅರ್ಪಿಸುತ್ತಾ ಪ್ರಾರ್ಥನೆ ಗೀತೆ ಮತ್ತು ನಿರೂಪಣೆ ಮಾಡಿರ್ತಕ್ಕಂಥ ಇಬ್ಬರು ವಿದ್ಯಾರ್ಥಿನಿಗೂ ಸಹ ಈ ಸಂದರ್ಭದಲ್ಲಿ ನಾನು ಧನ್ಯವಾದಗಳನ್ನ ಹೇಳಲಿಕ್ಕೆ ಇಷ್ಟಪಡ್ತಾ ಇದ್ದೇನೆ. ಕಾರ್ಯಕ್ರಮವನ್ನ ಇಲ್ಲಿಯವರೆಗೆ ಯಶಸ್ವಿಯಾಗಿ ನಡೆಸಿಕೊಡ್ಲಿಕ್ಕೆ ಕಾರಣಕರ್ತರಾಗಿರ್ತಕ್ಕಂಥ ಪ್ರತ್ಯಕ್ಷ ಮತ್ತು ಪರೋಕ್ಷ ಕಾರಣ ಆಗಿರ್ತಕ್ಕಂಥ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನ ಹೇಳಿ ನನ್ನ ಮಾತನ್ನು ಮುಗಿಸ್ತಾ ಇದ್ದೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ.
Thank you so much, sir. I request all the registered participants to kindly fill up the feedback form and submit the link for which is provided in the chat box in the meeting itself. Thank you, everyone. Here we may conclude for the day.
Thank you.